May I plead, Your Lordship? Lordship, I beg to mention item number 15. Petitioner wants to withdraw this petition because of some materials of facts are not disclosed in the petition. So petitioner may be allowed to withdraw this petition with liberty.
Mr. P. A. Ahmed, learned counsel for the petitioner, Mr. N. Goswami. Learned. Who is standing counsel? Revenue. J. Hendrick. Juk. J. Hendrick, learned standing counsel, Revenue Department. For the respondent number, so and so, J. N. Goswami, learned junior government advocate, Assam, for the respondent number 1, 2, 2 and 3. And Mr. J. Dekar, learned counsel for the respondent number 4 are present. First of Mr. Ahmed, learned counsel for the petitioner, has submitted on instruction, the petitioner wants to withdraw this petition at this stage with the liberty. With liberty. First of the learned counsel for the respondents have submitted that they have no objection to the prayer submit. In view of the above submission of Mr. Ahmed, learned counsel for the petitioner, the petition is dismissed on withdrawal with the liberty as prayed for. Seventeen. 17. You are for the AAAC.
Your Lordship.
Okay, who is for the petitioner?
My lord, please.
You are there.
My short date may be fixed, my lord.
Lordship.
Very old
It
matter.
will
my
be
lord.
after vacation only.
My lord.
Justification.
Old matter, my lord.
Mr. S.K. Singh, learned counsel for the petitioner, is present. Miss,
We show here, Lordship, on behalf of Mr. J. Chitya.
on behalf of Mr. J. Shutia, learned senior counsel and senior standing counsel KSC, has sought for an adjournment with the consent of the learned counsel for the petition and other respondents. First of, in view of the same, the case stands adjourned. As sought for, let the case be listed on after vacation.
3007.
Obliged to Lordship.
May I please, Your Lordship? Lordship, I beg to mention for listing one petition that was filed on yesterday, Lordship.
Petition.
Yes, Your Lord. The urgency is in the matter is that, Lordship, the petitioner being a minor, Lordship, praying for permission from this honorable court for termination of her pregnancy, Lordship. That is why
Termination of,
her pregnancy.
okay. Monday morning.
Money, Lordship, because
Tomorrow we have see big list.
I
May it please your Lordship. Lordship, this is with regard to item number 18. Lordship may like to recuse yourself from this matter.
List the case before any other events without me.
Lordship, there is one more item. This is with regard to item 22, Lordship. The engaged counsel is indisposed due to ill health. Lordship, this matter may be fixed after 2 weeks.
Item number,
22, Lordship.
okay. Yes, Mr. Joy.
Lordship,
Miss
B. Saikia on behalf of DJ Kapil, Lordship.
learned counsel for the petition has made a prayer for adjournment. Mr. K. Jain, learned
There is
counsel on
also
behalf of Mr. S.C. Kyle, learned senior counsel and special standing counsel GST, who is present, has submitted that he has no objection to prayer. Release the case after 3 weeks
Lordship. And Lordship, there is also an interim order that may be
on a date to
continued.
be fixed by the office. The interim order past writer shall continue till the next date of district.
Deeply obliged, Lordship.
May I please, Your Lordship, with the consent of the other side, Lordship, I beg to mention item number 23, Lordship, which I've already submitted an adjournment slip, Lordship.
Okay. Mr. R.
N. Kolita.
and Kolita. You are for ECI. And Kolita, learned counsel on behalf of Mr. A.I. Ali. And standing counsel ECI has made a prayer for adjournment. And I mentioned move to the consent of learned counsel for the other sides. And I mentioned move to that effect has already been circulated yesterday. In view of the same, let the case stands adjourned for
Lordship, after vacation, Lordship, can it be on 31st?
as sought for and agreed to by the learned counsel for the prayer is allowed, as sought for and agreed to by the learned counsel for the parties, release the case on side you.
4th August, 0408.
Yes.
Obliged.
Lordship, I beg to mention for listing of 3 writ petitions for motion. May-
For motion,
motion,
what is your subject matter?
GST cancellation, Lordship.
Monday. Mr. Atrio, we'll take up your case in the second half, later or after the admission matters. So that others can be free.
Supplementary list for
Any other
withdrawal.
business come at 2.
For withdrawal, item 25.
My lord, I pray to withdraw on instructions of my client, my lord. This was filed wrongly by us, my lord. Due apologies to us, my lord. Because, my lord, we have invoked Article 226.
Oh, that one,
Yes,
you
my
already
lord.
filed.
Yes, my lord. We have
Okay.
filed under the appropriate, my lord, that
Okay,
is
okay.
227, my lord.
Mr. H. Burawangai, Learned Counsel for the petitioner, and Mr. You were there?
Yes, Lordship.
You
I'm
for
for
whom?
2, 3, 4, and 5. Lordship.
Okay, Mr. Roy is there, SS Roy, Central Government Council. Okay, SS Roy, Central Government Council for the respondent number 1. And Mr. K. Corita, Learned Counsel for the respondent number 2, 3, 4. 2, 3, and 4 are present. 6 is not required.
5 also is that
Because
office.
otherwise,
That was the wrong, my lord, mistake on our part, my lord.
because we is a judicial authority.
Correct, correct. my lord. It
5
was
is,
a-
5 is also,
Mr. Burawangai, 5 also?
5 also is state officer.
I was inside, my lord.
I was here.
Person who has-
Okay.
I can accept.
But you are representing.
5 is state officer, Lordship. I was
By
here.
name, it is there.
Yes, no.
Okay, will not record that. Mr. Burawangai, Learned Counsel for the petition has submitted that the petition will be allowed to petitioner or it may be allowed to withdraw this petition in order to avail appropriate remedy.
My lord, we have actually already filed an application
Today
under,
list-
my lord, 227. Today only it is posted, my lord. So I made it a point that I would withdraw first, my lord, then I'll praise that.
In order to avail appropriate remedy. In view of the above submission, Mr. Burawangai, the petition is dismissed on withdrawal with the liberty as prayed for.
My lord, I'm highly obliged.
Daily list for motion, item 1.
In this case, the instruction was sought for, and today is the 4th day. And our submission has already been recorded by your loss in the first order file.
Just a minute.
400 and
He has
68,
been maintaining a bank account in
allegation
the
of-
cited
depositing.
earlier incident of
That was-
treating his bank account on receipt. Yes,
Yes, your lordship, as earlier, your lordship has already passed in many cases. So same order may be passed in this case, your lordship. Because
it is not bank freeze order. Where is the earlier order?
And your
You have
lordship,
approved earlier.
Is 16 my lord.
two writ petitions has been filed.
Is
your
16
lordship.
my lord.
One is for 796 and another is for 469.
That petition is pending or disposed?
That is pending, your lordship.
Pending.
Either both may be taken together, your lordship.
2, treating, 2, 8, 6. 1. How many petitions?
Two writ petition, your lordship. Another is 2641. Sorry,
Earlier- your
124,
earlier petition was?
124 of 2026.
That is pending.
Yes, sir.
Do you have any other instruction other than this 796 and plus 469?
Your lordship, there are so many
No, in his case.
in his case, your lordship, that other transactions are also that is under the suspicious transactions. But since we have received only
How much instruction you have received?
yes,
How many instructions you have received regarding his bank account?
there are two instructions.
Two.
Yes,
So on that basis, you have kept the entire,
entire account under the
so you have instruction.
yes, your lordship.
Part. Mr. M. H. Sodri. Learned Senior Counsel, assisted by Mr. T. L. Chaudhary, learned counsel for the petitioner. Mr. M. Sharma, learned counsel for the respondent number 1 and 2. And Mr. S. S. Roy, learned government counsel for the respondent number 3 and 4. The learned counsel for the parties have submitted that in view of the instructions available with them, comma, the writ petition can be disposed of at this stage. In view of the same, notice is made returnable forthwith, and the writ petition is taken up for final consideration. First of the petitioner has stated that he is a small businessman dealing in buying and selling of broiler chicken. And he carries out his business from he carries out business at Islampur Road. Which place? Your place
Yes.
business? Place of business?
Islampur, madam.
Islampur Road. Ulubari, Gauhati, Kamrup Metropolitan District, Assam. Post of. The petitioner stated that he has been maintaining a bank account bearing 10095450080 in the Gauhati branch of the Gauhati branch. Comma, ZS Road, within bracket the respondent number 2 of the IDFC Bank Limited. Respondent number 1. Para. The petitioner has stated that in an earlier incident, comma, earlier, comma, his aforementioned bank account was kept debit freezed on receipt of a cyber complaint filed in the state of Andhra Pradesh for a suspected illegal transaction rupees 796.19. Post of. Agreed by the event of freezing of the bank account, comma, the petitioner approached this court by way of a petition WPC number 124 stroke 2026. Stop. At page 13, it is reflected. Page 13, bank statement, this
No.
796 is reflected.
No, your lordship.
Hmm?
No.
No.
Put 69, no?
Whether the earlier one is pending,
Yes, it is pending, my lord. It is pending.
this is subsequent.
It is substitute. Earlier one is for 796 and this one is for 416.
So let it come to
Together.
tomorrow together. We
Yes,
can
sir.
dispose of both.
So both the matter may be disposed.
Right.
Yes, sir.
Otherwise, there is no interim order.
My lord, my lord.
Better to come tomorrow.
Yes, sir.
Learned counsel for the parties have submitted that the issue involved in this writ petition is also a similar issue is also involved in another writ petition WBC number
124 of 2020.
2026 preferred by the writ petitioner, same writ petition, and therefore both the cases be taken up together as sought for by the learned counsel for the senior counsel for the petitioner, expressing urgency list this writ petition along with WPC number so and so tomorrow.
Highly impressed.
Supplementary list, item 26.
May it please your lordship. In this case, my lord. The
Yes.
petitioner, my lord, we have came before my lord against the demolition of a setback deviations, my lord.
Setback deviation.
Yes, on the basis of a complaint that has been lodged by a person from Nagaon, my lord, having a attorney of a different plot of land, my lord. The complaint, my lord, is that.
Whatever setback deviation is setback deviation.
Yes, my lord. Yes, apparently.
Law takes its own course.
Yes, my lord, what has happened, my lord, there is a provision under the GMC, my lord, under the building bylaws, my lord, that it can be compounded, my lord, and can be regularized, my lord. Since the setback deviations as per, my lord, recently, my lord, the setback deviation is 6 foot in the rear and all the sides, my lord, but it is compoundable to 2 foot, my lord. So, my lord, that application is pending before the authority, my lord. And my lord, my only submission before lordship, my lord, at this stage, my lord, at least, my lord, before my representations regarding at page, my lord, 88, my lord, I make a representation before the authority.
Let us see the order first.
Yes, my lord, may I kindly come to the first demolition order, my lord, at page, my lord, 62, my lord.
62.
62, my lord. And thereafter, we prepare an appeal. 62, my lord.
Our GMC contribution.
This order is, my lord, against the petition.
Let me read.
Yes.
Whereas you have carried out the following nature of illegal arrest. R16 Assam Tribunal deviation in the schedule of payment below without requisite permission from the changing contravention in the billing bylaws. Fail to comply with the terms of the notice issued. So notice was served.
My lord, notice was served, the copy of the complaint was not given, my lord. It was thereafter, my lord, only on 6, my lord, 6 when you make a representation.
And they have a sumoto power also.
Yes.
They have a sumoto power
Yes,
also.
my lord. Yes, my lord.
Complaint is immaterial.
Yes, but not spot inquiry, nothing has been done, my lord. That is, my lord, there. No measurement, nothing, my lord. A very small house of 320 square feet, my lord. Two. And one, my lord, small
Question
house.
is not about
9
state back.
Yes, my lord.
Question is building without permission.
My lord, this is not, my lord, airtight, my lord, 2 room of 320 square feet house, my lord. This is constructed by my father, who is a mansion, and I am also a mansion, my lord. And my lord, this, my lord, even while during the construction of the road also, there was, my boundary was in post,
No,
my lord.
state back is different.
Yes,
But building without permission
Yes.
is different.
yes. The judgment of the.
Whether post facto permission can be given,
It can be regularized, my lord, because.
that I don't know.
Yes.
Then what happened in the appeal?
Appeal, my lord, it was, my lord,
Preferred.
affirmed, my lord. This order has been affirmed at page, my lord.
Referred under so and so.
My lord,
Challenging the final demolition order 18(3) issued by the commission. The matter originates from a public complaint by Sirajul Kantrodi on the background. He is adjacent.
No, my lord, he's a person from Nagaon, my lord.
No. He has a plot or not?
No, he doesn't, we don't know him, my lord. He's a, my lord.
I don't know, but whether
My-
the complainant is here.
For the complainant, lordship.
You are adjacent plot holder or what?
Lordship, We have.
Or you are public spirited person?
Yes, Lordship, please come to page 79. Lordship are on the.
Akhtar Huda,
Lordship, that is the power of
Ronak
attorney
Begum,
given by the
Ronak
landlord
Akhtar
to
Huda,
me.
Samsul Huda. Yes. Which paragraph?
Lordship, first, page 79, first one, that the Begum Ronak Akhtar Huda, wife of Samsul Huda, is a such and such. Lordship, hereby constitute Muhammad Siradul Islam. I am the complainant Muhammad Siradul Islam. I am the power of attorney holder. With respect to the same schedule of land.
No,
Hmm?
my lord, may kindly come.
Where is the schedule of land?
Schedule is at page 80, Lordship.
80.
80.
One kata 5 less covered by Dag number 384 KP Sohor Ulubari. Dag number 384 KP Patta 34. And petitioner's plot of land?
Petitioner's land is Lordship, it may come to page 86. That is the appellate order disposal.
No, my lord, I have annexed my cell deed, my lord.
Second para, Lordship. It is marked in bold, Lordship. Dark number 384, patta number 34. Revenue village, Sohor Ulubari part 1. Same.
No, 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 no.
No. How you are related?
Lordship, I was given power of attorney holder by the
Right,
landlord.
I have understood. Now, Samsuluda is because both the plots of land bear the same Nag number.
Number patta.
Right.
Correct.
That is your projection as per the power of attorney. Now, how you are related? How you are related? He is claiming to be the owner.
Yes, my lord, different Dag, my lord.
Just Dag number?
Different, my lord. My cell deed I have annexed. My is 85 and 86.
Huh?
And he has got an attorney in 84, 384.
Lordship, we have to go through the page
My
number
lord, my kindly
47 and
47
80.
Let me read it then.
Yes. That,
47
Let me read it.
Yes.
Now, in the order of the appellate order, Dag number 384, Patta number 34. Okay. Matter originates from so and so alleging. Okay. Notice asking for documents. Dated so and so was issued to the appellant submitted to the criteria going on. Where is your land details?
My lord, may kindly page 47, my lord.
Huh?
Right? Page 47, my lord. My cell deed, my lord, of 2000, my lord.
47.
Yes, my lord.
Tell me, where is your details?
Page 47, my lord.
No, in the body of the
In the
petition.
body, my lord, yes. My lord, may kindly page 6, para 3, my lord.
Para
Para 3. my lord.
Para 3. Kasim Ali. Under Gauhati Revenue Circle.
Para 6 be read, my lord. Para 6, page 8. my lord.
Are you the landowner of the adjacent plot?
Lordship adjacent plot, but they have constructed some.
No,
portion
I am
of-
asking the
Lordship.
adjacent plot or different at a distance. Where is his complaint?
Not his complaint at page, my lord, 75, my lord.
Schedule তোমার নাম তোমার কমপ্লেন ছিল তোমার কমপ্লেন ছিল তোমার কেমন লাগবে না 77 পেজ অর্থাৎ নাইট
Yes, now what is your representation?
My representation is, my lord, at page 88, my lord.
Where is the provision for any
My lord, that is there, my
relaxation?
relaxation, my lord, as per the 2014 building bylaws, my lord. The appendix indicates, my lord, that compoundable attempt setback is up to 6 meter, my lord. Say 0.60 meter.
No,
that
no,
is
that
2 foot.
question is not here. It is a question of no permission.
My lord, yes, my lord, it is there, my lord, that.
Setback will come later on.
Yes.
After permission,
Yes.
if one constructs a building
Yes.
and that violates the setback provision in the act or bylaws,
Yes, my lord.
then question of regularization of setback.
Yes, my lord.
Now the question of regularization of building, construction of a building without no permission.
Yes, my lord, now.
That is the question.
Yes. As per the, my lord, building bylaws of 2014, my lord, rule 18 by which they can regularize, my lord. Regularize, they can go for, my lord, measurement in rest NOC can be given, my lord. And my lord, in that issue regarding deviations can also be regularized, my lord.
You are, anytime you are deviation on setback.
Yes, my lord, setback, my lord.
But
Because
which rule?
the rule, my lord, it is, my lord, building bylaws, my lord. I'm just placing, my lord.
Building bylaws.
That
Yes.
book 18A, I think, 18,
Of which year?
2014.
2014, my lord.
Same repetition in 2022, that unified one also.
18, 18?
One, the modification plan.
Just a-
Modification.
Some penalty they will impose, my lord.
all plans, all modification of plans. This is modification of planning permit.
Yes.
There has to be a planning permit.
Yes. Modification of.
Planning
But
permit,
here-
planning permit will go to the GMT.
Huh?
They will calculate it, everything, my lord. Then it will come to the MC, they will get the NOC. Now, if he wants to, he submits that particular modification plan, my lord, he will have to go to the GMDA and get the.
Earlier, there was some permission.
No, there
No,
was
there is,
permission,
there is no
Huh?
NOC of this
Yeah.
building.
That is what I am
NOC.
asking.
There is no NOC on the bill. Now he have to go if that particular building stands as on date as per law. If it doesn't stand, that will be demolished. If the setback is that compoundable portion, non-compoundable. If there is not non-compoundable, that will be demolished. Only the building as per the present law, it will stand. If the everything is calculated, thereafter that penalty is imposed, he pays the penalty, that can be regularized.
Now, here is a situation. GMC assessed the house.
That is
Assessed the house in 1996. And he has been paying all the municipal taxes. Right. But question now, after say more than quarter of a century, you have, because of his complaint, now you have come up with this demolition order, right? But you have been also party to it.
no, my lord. There is a division bench decision, Sujata Pathak, my lord. Assessment will not propel the GMC, the authority to take action. Assessment will not give him a right to.
So first this
legal-
question whether this construction can be regularized
Yes.
or
First-
not.
First, we have to give an application. He wants to regularize it and pay the penalty and everything. Then the
Then the question,
then the
the next
question-
question will come whether this building is in conformity with the building bylaws or not.
whether that building
First, he
portion,
has to regularize, but his
An
building is to be regularized, is it not? Now, where is the provision for regularization?
18. My lord,
That can
that can go.
include this one.
This one. But that building had to stand as on date, had to stand as per the law. If it doesn't stand as per law, the entire building will go. Or the portion of the side where the setback,
Portion, my lord,
That-
it is there.
If the setback is not in conformity,
as per law, that non-compoundable portion will go, compoundable portion stand, they will have
now
to
what
pay
is
penalty
this
and everything.
application? His application page
There is no
88.
no,
My
This is
lord,
the
at page
appeal
88,
again.
my lord.
This is an appeal.
Yes, my lord. Prayer portion, my lord, at page 90, my lord.
Is there any provision for appeal like this, page 88?
My lord,
no.
Page 88.
page 8.
This order, mayor in council,
Yeah.
appeal.
Yes,
Yes.
438, there is a provision, he has exhausted it.
This is the appeal,
This is the-
438.
438.
Thereafter, any provision for appeal,
No.
then
No.
he is making an appeal.
My lord, I am praying for regularization.
He's making
Because-
regularization.
Because the
Prayer for
appendix-
regularization.
Yes,
Yeah,
yes,
for
yes.
regulation.
Well,
Before whom?
yes, before the, my lord,
That to
yes.
associate planner GMC.
He is the authority.
No, this had to go to the GMDA, that planning permit will come there. Thereafter, it will come to GMC. After that, all the calculation is made, penalty is paid. Thereafter, the GMC will issue the NOC as on date after 2014. Prior, it was different, but 2014,
So
since he's,
whether this is as per the procedure,
No.
page 88.
no, that will have to go to the GMDA with under section
No,
18.
after associate, suppose this has been received by associate planner. Let us assume for a moment, page 88.
Lots.
He has addressed this application to associate planner for regularization,
For GMC.
right? GMC. Now, this will suffice. This
No,
is
he
as
can
per the
forward it to
procedure.
the GMDA. He can forward it to GMDA to it.
No, it is associate planner who will forward it.
Actually, he should have gone to the GMDA. That this is the,
By the time everything will be finished.
my lord, now he have to forward it because this, or he have to straight away go to the GMDA. That he can forward it to the GMDA. That this is the application has come, you first get the permit. He will have to take all the boundaries will be calculated. They will put all the penalties and everything. After taking the penalty, it will forward it to GMC only to issue NOC. If it
Now, this
if the-
associate planner, after receipt of this application, he can take the steps?
he can also take the steps. He have to forward it to the GMD.
Or otherwise, if he runs from pillar to post in GMDA, by that time, this will be
It,
carried out,
Yes,
appellate
that
order.
that can be carried out, madam, because it's the final order, my lord.
Yes.
Final order is by the appeal also dismissed. They're only waiting for the demolition exercise as on date.
So he has an option to seek regularization before he has an option to apply for planning permit from the GMDA.
GMD will be the planning permit, all the calculation he will take the penalty, then forward it to the GMC. for only
With
issuing.
retrospective effect, post facto.
Prospectum, today's law, maybe building has come in prior to 2014, or is if there is a different law, now that law will be applicable, 2014. Because he is without NOC. It's a fact, my lord, they say, he has admitted this building is standing without
So
NOC.
planning permit with regularization.
Planning permit,
Planning permit with what? What is the term?
planning permit is the, when you accept application,
My lord,
it will give the planning permit, but all the NOCs and everything will be there. My lord, NOC, that all the planning permit with the setbacks and everything, it will be there. Thereafter, this will be sent to online to GMC. If it
So
is,
here it is, see, putting the cart before the horse. First, he has constructed a
Yes.
building. No planning permit.
No planning.
Right? No permission, either from GMC or GMDA. Now, building stands. Now, what is for him, how to do it? He has to have a design, architectural design of the existing building.
yes, we have to put an existing thing. There is also a provision now. The Mukhyamantri Sahaj Yojana, there is a there. That also you have to take the help of the
No,
minister technical person.
Unless you, either of you place this, how can I know Mukhyamantri?
No, there is
Yojana.
I can,
yes, my lord.
right now I don't
Yes,
have.
my lord, this is the appendix 3 of my lord, building bylaws 2014, my lord.
Huh?
It states, my lord, if a building.
Where?
Yes, yes.
First, take me to that.
Appendix 3, my lord. Appendix 3 of 2014 building bylaws, my lord, is a CL
Which
number.
page?
My lord, I'm just providing the copy, my lord, supplying the copy.
No, I have the book.
Yes, my lord, Lakshmi, kindly send it. Appendix 3, my lord.
No, which item?
My lord, Lordship may kindly say compoundable items, CL number 2, Roman 2, my lord. If a building or part thereof has been constructed unauthorizedly, that is without obtaining an requisite building
No, no,
permit.
not Roman.
Well, page,
I think 6.
the new, this book, my lord, it's page number
6.
Yes, maybe 6.
Appendix 3.
appendix 3. I am holding the appendix 3, my lord. There is a compoundable item.
Serial number 6.
Serial number.
Not setback or FAR, sir.
Yes, it is.
Mr. Alom.
My lord, it is mentioned, my lord, compoundable items coverage. FAR,
Right. It
setback.
is serial number 6.
Yes, my lord.
If not is holding that this book, there is no serial number 6 in this book, my lord.
Bylaws.
Oh,
Yes,
bylaws.
building bylaws.
Building bylaws.
bylaws.
Appendix 3.
Yes, my lord.
You are referring to setback.
I am referring, my lord, my lord, yes, setback, my lord, I have just compoundable items. But in a case, my lord, when the.
No, sir. Do you have any? Why you are referring to setback all the time?
No, my lord.
Mr. What Mr. Bora is referring to, it is item 6, perhaps.
see.
Look at it. Why you are referring to setback when you don't have any permission at all?
My lord, it is in compoundable item, it is there. my
No,
lord.
sir. Read 6. What is read 6?
Yes.
Read 6.
6 to 100.
Yes.
Read 6.
Yes. My lord, I'm just talking about this serial number 2, my lord. It is there, my lord. 6, my lord, is there, my lord. Unauthorized construction. If it
That is what I am referring to.
Yes.
You are referring to setback.
No.
I think item 6.
Yes.
Yes.
Why referring to setback?
No, my lord, I'm referring.
You are under a misconception. When your original building is without any permission, so it is completely unauthorized. Where is the question of setback? Whole building is to be demolished.
Just down below, my lord, this compoundable items, my lord, it is there, my lord. In that book, my lord.
That is what I am referring to,
Yes,
Mr.
sir.
Alom. You are referring to setback all the time.
No.
Unauthorized construction. If it is within the norms of building bylaws subject to satisfaction of the authority,
Yes.
that can be compoundable.
Yes.
The whole
Yes.
house can be made compoundable.
Yes, my lord. Yes, my lord.
You are referring to setback all the time. Now, who is the authority? Mr. Bora. Subject to satisfaction of the authority. Who is the authority?
Initial authority is the GMDA. We'll give the planning party.
This
Thereafter-
is the Gauhati Building Construction Regulation Bylaws.
Yes, madam.
Let us see it at the head. Building bylaws. Mr. Alom, you are confusing the court.
My lord.
All the time you are for setback. If the whole building is demolished, where is the question of setback? Guwahati Building Construction Regulation. Act. There is another act, Guwahati Building Construction Regulation Act.
That is 22, my lord.
Huh?
There is the unified, that is the latest one, the unified one, my lord.
One by one, sir. These bylaws are in exercise of Guwahati Building Construction Regulation Act. Where is the act? The entire book is of bylaw.
Yes, sir.
Have you understood?
Yes, my lord.
So, Asani Act of 2010.
10.
Same. Or conferred by section 4. Good. Bylaws আগত থাকে act পিছত থাকে কি কারবার when it is GMD or when it is GMC then?
No.
Our bylaws 2014 is in exercise of powers conferred by section 4 of the 2010 Act, right? And in the 2010 Act, it says authority means the Guwahati Metropolitan Development Authority, Guwahati Municipal Corporation, and other local body or panchayat as the case may be. So authority includes both GMD and GMC.
Now it is GMDA is the initial authority will give the planning permit. It will make all the calculation and give the planning permit, and it will be forwarded to the GMC, and GMC will provide the NOC. If the calculation is correct.
Now, which bylaw will come? Sorry. Which bylaw will come?
2014, section 18 will come.
But now there is a new bylaw.
There is a new bylaws.
2020 now.
22, same thing, my lord.
Huh?
Same thing, my lord.
No, same thing. That is gone or repeal or what? Mr. Alam, you are not very prepared. Take us to the provisions.
14 I have brought, my lord,
But there is a bylaw of 2020. Okay, amendment. Anything, any amendment to rule bylaw 18? If the authority is GMDA, then you have to how can I direct GMDA when GMDA is not a party?
GMD is not a party.
That consider his case for regularization of or compounding of unauthorized construction within a period of, say, 4 weeks. Till then, no decision would be taken on the demolition order. To do that, both the parties are to be involved. It is an admitted position that your building is unauthorized construction, right? Now is a case of compounding the unauthorized construction. As per Mr. Bora says that first you have to move the GMDA.
Yes,
It is in coordination of both the authorities. In the meantime, if you
yes, my lord.
make an application before the GMDA, in the meantime, GMC will carry out the demolition. So it will not be a case of regularization of unauthorized construction. You have to seek a fresh permission for construction of a new building.
In the
And I cannot,
Yes, my lord.
when GMD is not a party.
But in this case, my lord, since the matter has been referred to the GMC, my lord, it can be forwarded to the.
No, I cannot say that. Why
What
should
may-
I say? I cannot say that. That forward this, that there is nothing here.
So, my lord, kindly, my lord, in the meantime, my lord,
You make GMD a party.
we'll do one thing, my lord. We can make a representation to the GMD, my lord. In the meantime, this demolition part maybe, my lord.
No, I don't find anything to stay. I don't find anything to stay.
This,
It is an admitted position of unauthorized construction.
my lord. My lord.
I am trying to
My lord.
be in your favor,
My lord.
but question is on this petition there is nothing. Unauthorized construction, you have to make both of them a party. And if it is compounded, who is the compounding authority, Mr.?
GMC, my lord.
Compounding with the
GMD
GMD in the planning
Can
permit.
you be sure? If the
Yes, sir.
GMC is the compounding authority, then I ask them to consider.
Today is the GMC, not the
Huh?
GMC, GMD is the compounding authority. They will make the calculation. All these setbacks will be calculated.
No, where it is there? Tell me.
My lord, because
Tell me which, take me to a provision.
my lord, I will show.
I cannot, in the air, I cannot pass an order.
Let me
There
go
will
to
be
the-
havoc.
Yes,
Which
yes.
provision or which bylaw that GMDA is the compounding authority? Appendix 6, serial number 2,
Yes.
6. Please come again. Please come again.
Old book. No, don't do that.
Subject to satisfaction of the authority. Tell me who is the authority? Is there anything there? Authority means now in the bylaw it is not defined.
GMC एक में देखा तो एक है।
In the act it is defined GMDA or GMC as the case may be.
In the down below, when a compoundable part, lots will come to 4.
Four means what?
That appendix 3, my lord, 4.
Yes, I am at appendix.
Compounding items. 2 is compounding at 3 is rent and compounding at given to the schedule 1, 4, my lord.
Roman 4, my lord.
Roman 4.
Down below, my lord.
Down there is a note, my lord. Down there is a note. The authority may hire.
Roman 4.
Roman 4. Roman.
Initiate action as per provisions of the 1971 Act for building or rates for compounding. Gauhati Major shall initiate action as per so and so for building other in deviation from the hammer band. So GMC is authority.
Yes.
This is a thing building prior to 2011.
This is a building prior to 2000, but
See, building in deviation from the approved plan.
the authority granting the
No,
permission.
these are for where there is existence of some building permission, but deviation.
Yes. Here there is no building permission.
No building permission at all. Which one is the authority?
As
You be sure tomorrow. Be sure about it.
Lordship.
If GMC, then this petition will do.
Hmm.
But if GMDA, then this petition will not do. Have you understood? Because subject to satisfaction of the authority.
Lordship.
Entry 6. And who is the authority? Already demolition order. Original authority, appellate authority. We are not going to sit in appeal there. Only we can provide if there is provision for regularization of unauthorized construction subject to satisfaction of the authority. Let him get the satisfaction or not. That authority, only find out who is the authority. And you know that this building is from 1996.
Yes.
So according to that, there is some confusion. Find out. G. Alom, petitioner, as Bora, standing of the GMC. A. Kakoti, respond number 5 are present. As sought for, release the case tomorrow. Find out the authority.
Daily list for admission. Item 6.
Lordship, kindly pass over the matter for time being, Lordship.
Item 7 and 8.
Mr. P.K. Chaudhary, election 1, court number 1. Kindly pass on timing.
Item number 9.
Kindly the matter may be taken up after some time.
All will get adjourned.
Item 10. Item number 10.
He's here, he's the assistant coming. SK Talukdar.
Number 11.
Yeah, please.
There's an order of 10th March, which I would like your lordships to kindly take a look at it. They have not complied with that order, your lordship. It's a very detailed order of Justice Devashish Borua, my lord. He had directed them to.
Let me read then.
Yes.
Yes.
This order has not been complied. The principal amount was directed to be deposited by the learned judge, my lord. And the only question left open to be decided was the quantum, the rate of interest which I am entitled to.
No, even the 20 lakh has not been
That has also
deposited.
not been
Then
deposited.
where is the question of?
Yes.
Mr. Roy, what affidavit will do? It is an admitted position, 20 lakh was received by you
Lordship.
after the proceeding. Before the single bench, division bench review, SLP,
Lordship.
right?
Now only
Ultimately, auction sale has been declared null and void. So whatever you have received
Lordship.
during the auction proceeding from the petitioner, that amount is to be returned back. Each Sharma must be aware.
If Lordship kindly come to the additional affidavit filed by the,
When? Additional, in which case?
in this case, Lordship.
Huh? We don't have any affidavit at all. Where to speak of about additional affidavit?
Item 11. Lordship in item.
Any affidavit?
They have submitted as furnished as an
No,
affidavit.
this court does not have any. I couldn't. India's khali hai. No affidavit at all.
You can hand over my copy.
Additional affidavit? There is no affidavit at first.
Lordship. Here, Lordship, just in the affidavit.
Maybe in your file. It will be.
In fact, the order does not left anything to be re-agitated. It's a final decision insofar as the principal amount is concerned.
262.
If Lordship can kindly come to page 60, that paragraph 3, that your dependent beg to state that pursuant to the direction passed by the Honorable.
Just a minute. Submissions,
What is in कितने बिल्कुल 17 kali.
next to state resident revenues of highest later, such as amount of Received. Apart from this 2 bighas of land each to 5 of the petitioners, any other plots of land were auctioned?
Total, there was some
31 bigha.
24 bighas, I believe, which was auctioned, but we are not concerned with the
Right.
remaining bighas. We are concerned with the 12 bighas.
5 bigha, 10 bighas.
No, there were 12 bighas total, out of which 10 bighas. Your lordship is right. 10
5
bighas.
petitioners,
Yes,
2
5
bigha
two
each.
bighas each. Yes. So we are concerned with only that.
An amount of location, receipt, bank sheet number.
Right to stay. Yeah.
Who challenged the Bakija proceeding?
The landowners.
Hokan Puguri. Hokan Puguri, Nandlal.
Yes, Nandlal. This is the owner who challenged and filed a writ petition, where he succeeded, my lord, and the Bakija.
That I have
Yes.
understood. When it was single judge set aside the Bakija proceeding,
Lord, 16th March 2007, your lordship, the single judge accepted the writ
but
petition.
the money had gone out of the state coffer.
Yes.
That's what they are claiming now, after the order has been passed, that the
But
money
if
was
the, no,
deposited with the
but that fact
laborer.
cannot be ignored.
Yes.
That means that Nandlal, they are having both. Their liabilities were disbursed
By
and also
our
they are
money.
having the land.
Yes, our
At
money
your
was
cost.
utilized. Our money was utilized to pay off the laborers,
Right.
which was the dues of the
But
Nandlal.
that has been done by the state,
Correct.
right?
Right.
Labor Commissioner, they
Yes.
have disbursed at least 31 lakhs
Yes.
at that point of time immediately
Immediately.
to the staff of the,
Right.
right?
Right.
Because the estate defaulted. Auction proceeding was, so it is not that the state, and all the time the entire proceeding was up to 2020,
Yes.
up to it reached Supreme Court.
Yes.
Meaning thereby, all the time this Nandlal and Sons, they are having both, enjoying both.
Absolutely. Even till date.
Their say 1,000 laborers liabilities have been discharged.
Yes.
They are having the land.
Yes.
But
Only
question
within
is
me,
bona fide,
Your Lordship.
right?
Yes.
I know, but everything on putting the blame, that is an interim order during the course of the proceeding. Now the situation is different on the ground. This Nandlal is having everything.
Yes.
But you cannot blame also until they have disbursed. they did their duty at least. Us after receiving, so far they are bona fide at that point of time. About after receipt of the proceed from you through auction, disbursement, that point cannot be doubted.
No, but after 2007, once the Bakijai proceedings have been set aside, they have not woken up after that till today, Milord, till the time of filing of this affidavit. This is for brought on record for the first time, Milord, that the money has been
Right,
disbursed.
but it is set aside. It went in favor of the
That is Nandalal.
None.
Nanlal,
Nandalal, yes.
and then you prosecuted.
So the state did not. There were some other auction purchasers who took it up in revision petition and further went up to the Supreme Court, Milord, not me. So they ought to have taken steps to recover that money and refunded it back to me. Now saying, Milord, more than 2 decades after that, sorry, we have paid the money to the
So
deliverer.
all these writ petitions,
Yes.
writ appeals,
Yes.
SLP review,
Yes.
did you pursue?
No, I did
Ah.
not pursue.
Oh, you are also same.
No, insofar as I am concerned, Milord, my rights over the land.
No.
Where-
Since
where-
when 2007,
Yes,
the auction proceeding was set aside,
yes.
right?
Entire action.
Ah,
proceeding.
what did you do?
The Bakijai case was set aside.
Yes.
I pursued with them to return the money to me. I have, that is taken note of by the
No,
learned single judge. at
have you
paragraph 5.
taken any legal recourse?
Milord, because the proceedings were pending all the way to the Supreme Court. So I did
So
not file a
from
writ
your side, you have not.
I have not approached the court, Milord. That is a fact. I have, Milord, made representations to them. And, Milord, after the court case finally got over in the Supreme Court, Milord, which was on, Milord,
Then sir, make Nanlal a party.
Milord,
Nanlal a party.
After,
but
I'm
the
saying
state
because-
has to, Milord, recover the money from them, Milord.
Oh,
State has, Milord, today I'm, Milord, only on the limited point, Milord, the 10th March order is final insofar as the principal amount is concerned. All that I'm saying, Milord, is let them deposit it. They have the recourse of attaching the property also and recovering those amounts which are recoverable from Nandalal, Milord, as they are saying in this affidavit. My dues, Milord, there cannot be any lien over my dues, Milord. I failed in the auction. I did not acquire.
no,
the
your
right to-
conduct will also be looked into why this direction is final. Let us see.
My lord. Milord, may see the directions at paragraph 13, Milord. In fact, may I read paragraph 11 and 13 both, Milord? Paragraph 11, this court has given anxious consideration to the matter. The materials on record show that the petitioners had paid an amount of 20,05,000 to the respondents in the year 2004, for which certificates of sale.
So,
petition-
Mr. You deposit this 20 lakh 5,000. Whatever be the situation, or otherwise you have to seek recall of this order.
I filed a contempt also, Milord,
Uh-huh.
which is likely to come up anytime.
It is up to you. Otherwise, you have no other option to deposit at least 20 lakh.
to that effect, let
The direction stands as on today.
Lordship, yes.
Making an affidavit will not do.
Lordship.
Either you have to prepare an appeal or seek recall of this order.
Lordship, give us some time, Lordship, let me have the instruction.
Otherwise, you have no option.
Lordship, I've seen.
You deposit. Thereafter, you seek recall.
Lordship, let me have the instruction.
Both time, Milord, they have come seeking instruction.
How much time you deposit within 15 July?
Lordship, let it be come after the vacation.
Deposit it. Already court has observed in the previous order, 2/6/2026. Court took note of the fact that 20 lakh 5,500 was directed to be deposited, but you said that only 9 lakh 81,470 can be deposited.
Yes, because this was bad,
And which order is not challenged.
Lordship.
So you ensure that these are deposited. Heard Mr. A. Fukan, learned counsel for the petitioner. And Mr. S.S. Roy, learned junior government advocate for the respond number 3 petitioners. By order dated a number of directions were made in an order dated 10/3/2026. First of one of the directions is to the respond number 2 and 3 to refund the principal amount or rupees 20 lakh 5,500 any time period.
Milord, we were directed to furnish our bank accounts, Milord, which we did to them along with the certified copy on 20th of April. So they were supposed to, Milord, give the money, Milord, within 15 days from that date, which would have expired on 5th of May, Milord.
The time period allowed to deposit the said amount, comma, as per the said order, comma, has already expired. First of the order dated 10/6/2023 has not been challenged in any manner by the state respondents. In that view of the matter, comma, the said amount, the respondent number 2 and 3 shall ensure that the amount of rupees, the entire amount of rupees 20 lakh 5,500 is deposited, is disbursed.
It's released in the bank
Is
account of the petitioner.
is
Deposited in the bank account of the petitioners.
is to be released in favor of the petitioners on or before
Lordship,
today is 2007/2026 without fail. In the event the same amount is not deposited, comma, the petition and the respondent number 2 shall appear. Respondent number 2 shall appear in person, which is to be facilitated through the virtual mode. List the case on 20th
July, Milord.
24 July. Let him deposit by 20/2007 or otherwise let him explain why he could not deposit.
My lord is listing the matter on what date?
24.
Would it be on 27th, Milord? I can be present.
27.
Deeply obliged.
Right. You tell him that otherwise he has to appear, but through virtual mode also to explain in case of any default on his part.
Deeply obliged.
Item 12,
Please, your lordship. PK is still in proceeding, my lord. Code number 1. My lord, we are required to file an, my lord, affidavit, my lord, to the interlocutory applicant. My lord, further a week's time may kindly be granted because, my lord, the writ petitioner has suffered an injury, my lord, an accident.
You are for
I am for
petitioner.
the writ petitioner and, my lord, they are for the private respondent 6 and 7. They have filed an IA for vacation of
Okay,
the.
you want to file an objection?
My lord, my lord.
Okay. Heard, Mr.
Yes, sir.
S. Amir, learned counsel for the applicant, and Mr. A.R. Bhuyan, learned senior counsel for the
Writ petition.
opposite party, that's writ petitioner. First of Mr. Bhuyan has submitted that the opposite party, number 1, writ petitioner, is presently disposed in view of such situation, comma, the objection to the interlocutory application could not be filed in terms of the previous order dated 25/05/2026. He has sought for further 2 weeks' time to file an objection to the instant interlocutory application. First of prayer is allowed, raise the case on so and so. Who else are appearing? Ms. Arbora, standing counsel, NHI DCL, and Mr. H.K. Hajarika, learned junior government advocate for the state. Respondents are present.
2207.
In the
Obliged.
interim order past release shall continue
Mal.
till the next.
Mal. Obliged.
Item 13.
This is a matter relates to election of the Gaon Panchayat President, my lord. My lord, we have preferred in my lord appeal under section 11 of the Gaon Panchayat Act before the Deputy Commissioner, my lord. When there is a dispute regarding on the first meeting, my lord, there is a provision under the statute that the aggrieved members can prefer, my lord, and when the my lord all allegation has been leveled therein, my lord, in the appeal, the Deputy Commissioner has rejected our ground, my lord. So therefore, my lord, the challenging the speaking order, my lord.
Okay.
This and they have filed an affidavit yesterday, my lord. Certain facts has been revealed here. They have admitted, my lord, that there was a peaceful meeting was held, my lord, that the election of the
Let
president.
it
can-
come on record then, if
Mile.
any file, heard Mr. A.R. Will and Senior Counsel is stated by Miss Learned Counsel for the petitioner, Mr. N. Goswami, Learned Junior Government Advocate.
For 2, 3 and 4.
Assam for the respondent number
2, 3 and 4.
2, 3, and 4. Miss P. Thapa, Miss
One, on behalf of S. Dutta.
S. Doctor. Your name, please?
Arbora.
Arbora, Learned Counsel on behalf of
Whom appear for
Mr.
next.
S. Doctor, Land Standing Council, Panchayat and Rural Development Department for the respondent number 1. Who else?
My lord, none appears till date.
4, 5, 6, and 7?
Up to 9, my lord.
Okay. Despite service of notice, none has appeared for the respondent number 5 to 9 till date. Para. Mr. Goswami has submitted that an affidavit in opposition on behalf of the respondent number 2, 3, and 4 has been filed today or yesterday?
Yesterday.
Yesterday. So, with a copy to the Learned Counsel for the petitioner, as the said affidavit in opposition of the respondent number 2, 3, and 4, stated to have been filed yesterday, is not on record, or is to trace out the same and to trace out the same to tag the said affidavit with the case record. Release the case on so and so. The petitioner, single petitioner.
No, my lord, we are altogether 5, my lord.
The petitioners may file their reply affidavit in the meantime, if so advised. Release the case.
2207.
Mal. Obliged.
Item 14.
Limited prayer formal consideration of the representation, page 33, my lord. So the matter was
Sale with plot
page
of
33.
land. Plot of land on the
Hearing, where is it? Hearing, where is it? Yes, notice to Korea. DPN. I'm not paying it. Anyway, the next one was right one. Yes, it's one. Sir, my not here to answer. Take it. Six.
disposal of the representation. So first you
Yes.
establish your right.
Yes.
Wow, generally this court does not dispose of
Right.
petition for consideration of representation. Now you entered into an agreement for sale of land. What substantive, when the acquisition proceeding was initiated? When is the notification?
My lord, notification.
Under what act, firstly?
Notification was issued by under section 6(1) of the Assam Land Acquisition Act 1964. Now question is that, my lord, since.
Where is that? Where is that? Date, date, date.
Notification, I don't have, because my lord.
Date, only date,
Date, my lord.
date.
My lord, that is actually. Lordship, we have just, my lord, received the
What is
information. We have.
crucial
put our
is the
objection.
date of the notification.
My lord, my lord. No, Lordship, may I say one thing, my lord? Only, Lordship just want to show that whether what legal I deserve.
No, the dates are crucial.
Yes. My lord, notification.
Dates are crucial,
Yeah,
and that is why,
that's
please,
quite right, my lord.
your date of agreement for sale is 31/5/2011.
Yes.
One that is now available. One that is available. What is the second date?
I don't have, but it was, my lord, acquisition proceeding was initiated afterward, my lord.
No,
Now-
tell me the date. Everything depends on the date.
Date, my lord, date, my lord, right now.
Laws are settled.
Yes, my lord, so far the date is concerned, right now.
I don't want to confuse the deputy commissioner.
Absolutely. Lordship, may I pray on?
First, you tell me.
Lordship, only one thing. Lordship, just look for a moment, my lord, page 40, my lord.
I will not look.
Lordship, think they have already.
Tell me the date of the notification, acquisition proceeding. Order, section 3 order, section 4 order,
Yes.
and section 6 order.
But actually, Lordship, what?
Because
the
Section 4 will say that we have intended to requisition the land.
Yes.
Then section 6 will transfer it to Land Acquisition Act,
Yes.
right?
Yes, ma'am.
So intention to acquire land will be under section 4.
Yes. Intention.
No, intention no, acquire,
Yes, ma'am.
acquire, and for permanent purpose.
Yes. ma'am.
And section 3 that we are thinking of requisition the land for a public purpose.
Quite right.
So
Now, Lordship,
money disbursed.
no, my lord, money is not disbursement.
So let us have the idea
we have
first. Your locus
Yes, ma'am.
to claim
My lord, locus is in Lordship.
1,45 lakh.
My lord. My lord, so far the locus is concerned, possession is one of the core issue, my lord. That in respect of my lord, Land Acquisition Act, my lord, possessor also deserves certain rights.
The
to get-
initiation of the land acquisition proceeding, one of the most crucial point.
No doubt, my lord. Actually,
Do you have the dates?
right now I don't have that.
No,
Actually,
then
Lord-
Mr. Goswami will provide
Lordship,
in their affidavit.
Lordship, LTD, only LTD. Lordship, can you just look for, my lord, they have already issued notice on last.
Some 26/12.
26/12.
To the both the parties, Lordship.
Both parties. Therefore, my lord, only humble prayer that since notice has been issued, a time frame will be given to dispose of my lord, whatever my representation says about. that.
What notice?
My lord, last notice was issued.
Which are notice?
This one,
So they have given some application, Lordship.
26. Initiated proceeding, my lord, page 14. Notice issued appear to the, my lord, page 41.
Parties.
Out of which,
Okay.
my lord, we have been
LA
directed
case
to, not, they
number?
have been kept abandoned, my lord. That is my grievance, my lord.
LA case number so and so.
Page 41, lord.
7.
Under which act now?
My lord, basically, it will come under compensation parties, my lord, right?
No,
to-
no. Where is the, for what purpose it was?
My lord, page 41, my lord, notice issued to the both party.
I have seen now, page 41. You have staked your claim
Yes, ma'am.
for the entire amount or a part of it, whatever.
My lord.
1,45,49,316.
Yes.
Under which act now? It is 1894 or 2013?
My lord, basically, my lord,
2013.
2013.
2013.
Clear, no?
Right to fair compensation,
2013.
2013, it has been at that time, my lord.
Now, whether he has the power to decide on it.
No.
My just,
He has the
if suppose, my lord,
He has
if-
the power.
No, no, I'll examine. I don't want to create more litigations out of it.
then lordship,
Whether he has the power.
exactly notification required lordship, I think there
No,
is
no. Where is the power
No, no.
power, man.
to decide about
About-
additional district commissioner
My lord,
to decide about apportionment of.
My lord, actually, my lord, in such a disputed fact, even my lord, they can take a alternative recourse also, my lord.
No,
But,
sir.
but-
No, sir.
Lordship, kindly see there, my lord, conduct that after issuance of notice, the matter has been kept abandoned, my lord. We want a logical conclusion, my lord. Whatever, my lord, they want to refer it to the, my lord, to the appropriate form, we don't have any objection.
That you make an application.
No, absolutely, but lordship, let them first, my lord, it is their notice, page 41, my lord. Call the both parties for repair for hearing, they have kept abandoned, my lord, issues. Whatever they want to say, but they have to reach a logical conclusion, my lord.
Section 76. Section 7.
Dispute as to apportionment.
If any dispute arises as to the apportionment of the same or any part thereof, or as to the person to whom the same or any part thereof is payable, the collector may refer such dispute to the authority.
So therefore, lordship, can see page 41 is since the both party called for now thereafter.
Yes, Mr. Are you referring this or you are issuing notice?
We are issuing notice.
Huh?
That cannot be lordship. That cannot be.
Take your instruction.
No, they have issued notice to the parties.
For what? To
Because-
decide.
To do the hearing, my lord. It seems, my lord, my prayer is only limited, page 41.
No, it was Somaria. When something comes to my notice,
Absolutely.
an act
Illegality, yes.
which is without jurisdiction, why should I close my eyes to it?
Absolutely. No.
Mr. Somaria, please, please,
Absolutely.
when something is done by authority,
Wrong.
and I am quite aware
Yes.
that this is done without jurisdiction, why should I direct the authority to
Yes, absolutely. We do
bring
not
the
want
proceeding
out of
to
turn,
its
nothing we want.
close? Have you understood my dilemma?
Yes, quite. Let them clarify, my lord, that under which, my lord, law it was, my lord, conducted.
No, he has no jurisdiction.
No, yes.
Has he referred the matter to not
No,
to the authority? Take your instruction
My lord.
by Monday.
He has not-
Otherwise, I will say he will have no jurisdiction, he should refer the matter to.
Yes, he has not referred, law. It seems lordship. I have the instruction.
So let
Lordship.
him make aware he is doing something without jurisdiction.
Yes.
He has a claim,
Yes.
let the authority decide,
Yes.
judicial authority.
Yes.
Heard Mr. Somorial and counsel for the petitioner. Yes, who is for the respondent? Private? Private?
Names
Private?
one, lordship.
Names are showing.
My lord, instruction stage, notice is not. Oh, sorry.
G. Hazarika, Revenue 1,
I'm for 2, lord.
and Goswami 2. None has appeared for the respondent number 2, 3, and 4.
3, 4, 5, man.
3, 4, and 5. Despite call and reflection of their names and reflection of the names of the learned counsel in the cause list. Post of para. From the position made in this writ petition, it transpires that the petitioner has made a claim for in respect of an amount of rupees 1,45,49,316, which amount has been determined as compensation payable in respect of a parcel of land acquired by the provisions of the Assam Land within bracket Requisition and Acquisition Act 1964. So the respondent number 3, 4, and 5 are also the claimants in respect of the same amount, said amount of compensation. Post of para. Section 76 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, and Resettlement Act 2013 reads as under. Para. It is informed from a notice dated 26/12/2025 appended to this writ petition as annexer. Stick,
Page 41.
comma, the respondent number 3. Sorry, 2.
2, my lord.
2 has issued notice, says, to the petitioner and the respondent number 3 for their appearance before him, issued notice. along with all supporting documents in support of their claims to ascertain land compensation. Full stop. Mr. Goswami,
He has issued another notice on 10/6/26 also. It is.
KNC, Mr. Goswami has submitted that another notice of similar nature has been issued
10/6/26.
to the notices for the claimants for the said amount of compensation on 10/6
26 to appear on 29/6.
to appear on 29/6/2026. Full stop. In view of the above the fact situation, comma, the respond number 2 is to Mr. Goswami is to obtain instruction from the respond number 2 as to whether any steps has been taken from his end to refer the matter to the authority in terms of section 76 of the 2013.
Madam.
You fight it out before the
Yes, absolutely. Madam. That is our object otherwise also.
release the case on Monday. Monday.
Well,
I have given him a hint.
2206.
On 24.
Basically to give hint that
Monday.
wash off your hand.
Yes, madam. But that's why
Send the matter
this
to-
episode has to be shut down, madam, first.
Item 6.
My senior is still on legs in court number 1, Lordship. Timing, Lordship. After sometimes.
1 o'clock after that second half, we'll take up some other matters, some barthead matters.
7 and 8.
This map, my lord, regarding map. So map, the map which they use, there is some suspicion, my lord. That is why circle officer is directed to bring the correct map. So demarcation we challenge because through correct map it.
Talukdar.
Ma'am.
Vijay Talukdar.
My lord.
Twenty-one 4/2000. Forward. Waited 1/6/2024 order,
My lord, page 17.
page 17. Page 17 of
79,
79.
yes.
79.
Some ducks, my lord, scraped out old 205. Now, when in.
No. Only I have asked about the order, not your explanation.
My lord, page 79, my lord, 160.
All those dark numbers.
Being Pata has been issued to different persons and they are in possession, how could he come over and ask for a demarcation to other
Where is
party?
Mr. Talukdar?
Page 102 of the government affidavit.
Because the case of the state power doesn't pass in order
Circle officer, respondent number 2.
old trace map.
Old trace map, my lord, new trace map, page 63, my lord. There's discrepancy is there. 202 duck number enter into 205 duck number, my lord, new duck numbers. So that is why your lordship in last occasion, my lord Justice Deveris Burwa has pointed out that why it is this. Because 205 is a continuous. From 202, it should not enter into.
No, let us ascertain first.
So
whether
that should be explanation should be there.
it is for the map.
Map, my lord. And if
Then
wrong map
I will
is.
hear your submissions. Don't waste your energy right now. Yes, Mr. PK Mehdi. No map.
My lord, one thing, my lord, your lordship will look into it. 202, I am their private respondent. Nothing related to 205. 205, my lord, Pattadar has been different Pattas. That number has come,
So on the basis of materials on record, we have to decide it.
my lord.
Is it not?
My lord, the affidavit says the different Pattadars are on that.
Hear you out on another date
My lord,
for disposal.
it was heard by that.
No, I asked for it, your submission on the previous date.
My lord.
I put to you, both of you, is it not that the previous order of the coordinate bench indicated that list the case on further hearing?
And only
Then,
because,
then you proceeded to make submission, right?
Right.
So I heard you out.
Yes, my lord, that's correct.
Now it is not open for you
My lord, my lord.
to
I-
make submission that the coordinate bench has heard it substantively.
My lord.
Don't make such submission, Mr. Borua.
No, my lord,
I asked both of you,
I am not against, my lord. My lord.
All on my
and
side.
you said
I'm comfortable.
you went on making submission.
Yes, my lord. I am also comfortable with lordship. My take.
Now don't make, it is not open for you now, today.
I just pointed out that map that justice.
Don't make
program.
such submission.
All my lord, your lordship.
Okay, then I'll put it.
My lord, date may be fixed, my lord.
Yes, Mr. Roger,
My lord,
let it be.
my lord, on his behalf, I am sorry, my lord. I am,
No, no, he has made such submissions.
my lord, I am going by my head before lordship. On his behalf.
Mr. M.J. Borua, Learned Counsel for the petition has submitted that the coordinate bench of this court has heard the matter substantially and the matter be posted before the said bench. Post of Mr. B.K. Roychuri, Learned Senior Counsel for the estate by Mr. A.K. Rajat, Learned Counsel for the respondent 4 and 5, Mr. B.J. Taluda, Senior Counsel, estate by so-and-so for 2 and 3 are present in view of the above submission made by Mr. Borua, registry to verify the same and thereafter list the case before the.
My lord, I'm sorry, my lord, that's my contention is.
Item 9.
With your lordship. Lordship,
Yes.
this case, the petitioner's contention is that lordship, due to high tension overhead lines snapping, there are some damages to the trees and houses of the petitioners. For that, he claimed damages, lordship. This is the third round of litigation. Earlier, first round of litigation is ordered annexure to page 17, and it starts from 18, lordship.
You are Siddiq Abdul Rahim.
That petition was dismissed, but there was a direction
Direction to
from the pleadings. The following facts emerged. The transmission tower as referred to in the writ petition was constructed in the year 1987. For the aforesaid construction, land measuring 1 bigha 3 katha 5 lesa was acquired by the authorities, for which compensation of rupees 36,630 at the rate of rupees 22,000 per bigha was assessed and paid. The payment was received by one Abu Hanif Haidari, the petitioner number 5, on behalf of his father, who was the recorded pattadar of the land. The petitioner numbers 1 to 6 are all brothers and petitioner numbers 7 and 8 are their cousins. The receipt of the aforesaid amount has not been disclosed in the writ petition. The claim of the petitioners for compensation on account of damage of their lands because of the high tension overhead lines traversing their land would require factual determination. For all the aforesaid reasons, I am not inclined to entertain this writ petition. Accordingly, writ petition stands dismissed. But notwithstanding the dismissal of the writ petition, if the petitioners have any grievance over the high tension overhead lines, it would be open for them to take recourse to the provisions of Section 68 of the Electricity Act.
this is a electricity line, overhead electricity line. So it will be not acquisition.
Yes, Lordship, that is, though
Not
it was
acquisition.
not stated by the petitioner, that is a different aspect, Lordship.
But for what is that called? A right to user or what?
Yes.
Right of way.
Right of way.
Yes,
Right of way. For that compensation is payable.
Paid,
Lordship.
That has been paid.
paid.
Yes.
So thereafter, what's this provision of 68 is
68
about?
68
Electricity
is
Act.
about, Lordship, of the Electricity Act 2003.
That is so far right of way compensation that has been done and dusted.
That is a different aspect, Lordship. Even
Ah.
though they have not disclosed, that is not related with
What
this
is
compensation.
68?
Overhead lines, Lordship. Section 68 relates with the provisions relating to overhead lines. An overhead line shall, with prior approval of the appropriate government, be installed or kept installed above ground in accordance with the provisions of subsection 2. The provisions contained in subsection 1 shall not apply in relation to an electric line which has a nominal voltage not exceeding 11 kilovolts and is used or intended to be used for supplying to a single consumer in relation to so much of an electric line as is or will be within premises in the occupation or control of the person responsible for its installation or in such other cases as may be prescribed. The appropriate government shall, while granting approval under subsection 1, impose such conditions, including conditions as to the ownership as appear to it to be necessary. In my case, it is applicable only 65 and 6. Lord.
This 68, 68. These are things which are prior to stinging the overhead lines.
Lord, 5 is there. 5 and 6. Where any tree standing or lying near an overhead line or where any structure or other object which has been placed or has fallen near an overhead line subsequent to the placing of such line interrupts or interferes with or is likely to interrupt or interfere with the conveyance or transmission of electricity or the accessibility of such any works, an executive magistrate or authority specified by the appropriate government may, on the application of the licensee, cause the tree, structure or object to be removed or otherwise dealt with as he or it thinks fit.
This
Six.
is meant for the transmission licensee.
Yes, Lordship. To be-
Subsection 5. You
Yes,
have no role there.
No, Lordship.
Then
6 says when disposing of an application under subsection 5, an executive magistrate or authority specified under that subsection shall, in the case of any tree in existence before the placing of the overhead line, award to the person interested in the tree such compensation as he thinks reasonable, and such person may recover the same from the licensee.
Structure place that has fallen here. Interest or interest.
Five years before installation, Milord.
These are
Before installation and after installation 6. When disposing of an application under subsection 5, an executive magistrate or authority specified under this subsection shall, in the case of any tree in existence before placing of the overhead line. So we came to this plot of land after 1966, and thereafter we constructed our house and tree.
the overhead line was installed when?
1987.
87.
1987.
Yes, but that is admitted
Then you came to this place.
after 1966.
Then you have no right. As simple as that.
No, Lordship, after 96.
Everything is subsection 5 and subsection 6. any tree in existence before the placing of the overhead line.
Lordship. So any damage caused to that tree.
Which,
and-
that already compensation that within that embraces every amount.
Lordship, that is for
And if
acquisition.
you are say aggrieved, then it is subsection, section 16 or 10 of the Telegraph Act.
16, my lord.
16.
16.
And for that limitation is gone long back.
Section 16, my lord.
Section 16. Read with section 10 of the
10 of the
Telegraph Act,
Telegraph Act.
1885.
85.
Right. So,
But Lordship, we have already came to this court in the year 2011. First
oh, this
we
is an,
came-
but this has to be tested
Lordship,
by the provisions of section 68.
but court held that as per section.
Court has
16.
said now will have tested it.
Lordship,
What is section 68?
and Lordship, ADC already.
Fact is
acquired.
87 installed line. 96 you came to our premise.
66, Lordship.
Huh?
66, before 87.
Whatever 66 or 80, 96. 87 installed.
Lordship.
Compensation was paid. Anything, if you are aggrieved, this section 68 is to be read with section 10 and section 16 of the Indian Telegraph Act 1885.
In view of 164 of the Indian
Yes,
Electricity,
164 of the
Indian Electricity Act,
Act
2003.
2003. So this is correlatable with 10 and 16. Aggrieved, district judge. That might be an indication of the coordinate bench.
Lordship,
And
the
provided limitations subsist. My tentative understanding. Now, this is first round.
Lordship, first
What
round,
is second round?
Then annexure 3, Lordship, that is page 20. There is a communication by additional deputy commissioner to the assistant general manager, substation division. That please find here with the original copy of joint survey report of Jirat structure submitted by the circle officer, Boitamari Revenue Circle in respect of Mohammad Siddiq Abdul Rahim, that is present petitioner, of village Bhatipara, duly signed by the all related departments. In this regard, you are requested to take necessary steps for payment of compensation to the affected beneficiary as per joint survey and assessment report with intimation to this office from your end. You are also requested to ensure the protection of the family as per provision of section 68 of the Electricity Act 2003. The detailed compensation as shown follows.
Under what authority?
Under one.
Protection, okay. Transmission licensee has a duty that its overhead line is kept installed properly. Done. That part, protection part is okay. Because overhead line over your
But
premise,
Lordship,
because
that's
they have not got the right of landowner.
Lordship,
They have only right of way. Protection, okay.
Lordship.
So far as compensation is concerned, where from he has derived the authority?
Lordship, right of way compensation we already received, but
Received.
right of use of this land,
No, that
we have,
if it is not a equated monthly installment or yearly installment or decade installment, it is one time. But if any damage occurs,
Lordship,
for that compensation.
damage occurred
But
due
it
to
is
the
not a
negligence of the
continuous kind
department.
of thing that they will go on paying. But if you are agreed by that fixation of 22,000 and payment of 36,000, otherwise you have the right there which you have lost by way of limitation.
Lordship, the snapping of the high tension line took place 3 times, Lordship, due to the negligence of the department.
When?
Over my house and over my Lordship.
When?
2010, 2011 and 2022, that is admitted. But they said that. after-
Where admitted? Then what is the second round? Let us see.
Lordship, that is annexure 4, page 21.
2022. Let me read.
While residential campus of the petition other persons on the high tension and fail over the property 1996, 2010. Nineteen 92. Giving Para 6.
Yes, Lordship. 5,
Please read.
8. A reading of the provisions of section 68(5) of the Electricity Act of 2003 makes it discernible that it is not a provision of law enabling any compensation for properties upon the overhead lines being constructed by the electricity authorities, nor it is a provision for payment of damages of any property which may be lying below the overhead lines in the event the overhead line snaps, resulting in any damage being caused. In view of the provisions of section 68(5) of the Electricity Act, we are unable to accept the survey report prepared by the Assistant Executive Engineer of the PWD, nor a legitimacy can be given to the communication of the Additional Deputy Commissioner dated 23/2/21, directing the AEGCL to pay the compensation that has been assessed in the survey report of the Assistant Executive Engineer of the PWD. From such point of view, the prayer made in this writ petition for a direct
Letter is gone.
that ADC inquiry is
ADC
not
letter is
taken.
gone.
Yes, Lordship.
Now let us see, but at the same time.
But at the same time.
Huh. Provision is provided that. Disposing.
Page 28,
27, 28, paragraph
to-
8 is the directive.
paragraph 8, but so far as 28, page 28, this fourth line, in the application, the petitioner may also take his stand that no compensation was earlier paid in respect of the residential houses and trees that stood prior to the construction of the overhead line. This is meaningless. After holding in the previous paragraph, this line is meaningless. Said aspect of the application claiming compensation for the residential house and trees that stood prior to the construction of the overhead lines may be referred by the so and so to be dealt with the executive minister so and so, so and so. I don't think this is
So there
any
will be-
meaning. This carries any meaning. Once it is closed, closed. First order closed, second order closed. Again, this part is not in alignment with the earlier view already held. You may have been given opportunity, but already the issue has been decided.
That inquiry report was not taken
No,
into
no.
consideration as because
Previous paragraphs,
Lordship.
it has been foreclosed, already closed. That by the first, in the first round,
Lordship.
it was closed. Whatever was paid was paid.
First paid, there was nothing paid, so there was a direction.
No,
to
there
under
was
this- under
suppression
section 16.
also.
Lordship.
Suppression also,
That is for acquisition, that is for you.
not
way.
acquisition, right of way.
Yes, Lordship.
Right of way does not give you any provision for land compensation like Land Acquisition Act, only right of way. So this is redundant. Let us again read paragraph 8.
Accordingly, we require the present petitioner, who was also a petitioner in WPC 1981 of 2011, to make a fresh application before the managing director of AEDCL, stating in detail as to when the snapping of the overhead lines had taken place and what were the legitimate properties of the petitioner that were damaged because of such snapping. Upon such application being made, the managing director is directed to make a thorough inquiry on such allegation, and for the purpose, the petitioner shall also make an application before the senior chief electrical inspector of the government of Assam, who shall make an inquiry and give its report. If the report of the senior electrical inspector as well as the conclusion of the managing director is in favor of the petitioner that his properties were damaged because of negligence on the part of the AEGCL due to the snapping of the overhead lines, appropriate compensation be assessed and paid to the petitioner.
Yes. Stop at there.
Lordship.
These two reports may be of relevance, electrical advisor and managing
Managing
director.
director.
The later part of the previous paragraph, I don't think it has any relevance. In the application, the petitioner may also take his stand that no compensation was earlier paid. Already done and dusted. Paid. Suppression, everything has been done.
Lordship, that is in respect to 2010 snapping and 2011 snapping. There were 2 times snapping in the year 2010.
Let us see what happened there.
Then we have filed an application. That is annexure 5, page 30. Representation to the managing
Ah.
director.
Then where you say that, which year?
We have filed it
7/9/2022, 1996, 2010.
11/1/2023. We have filed this representation.
And you said that snapping took place 1996, 2010, 7/9/2022.
Yes, Lordship.
Okay. Then where is the report or inquiry?
Inquiry report, that is page 34, annexure 6. This is impugned in this writ petition.
So these are findings of fact. It cannot be said to be perverse.
But Lordship, it
And
is-
only if the single judge has held that only if report comes in your favor, the report has not come in your favor, and this is finding of fact by electrical advisor, quoted. On the basis of that, one Mondal's report, some fact were recorded. In a writ petition, we are not into adequacy or sufficiency of the region. Had it been perverse, we could have said so.
But Lordship, by this report, they have admitted that snapping was taken
Yes,
place in 3
at the
times,
same time, no, all those are gone.
2010 and
7/9/2022 was the snapping incident.
Lordship.
And you have planted tree in the meantime. This is
That
a
is
finding of fact.
Lordship. That is their contention in the inquiry report.
This is finding of fact. They are the fact-finding authority. We are not.
Lordship.
I don't think.
Intellectual right of way 35 meter, width,
Both sides.
both.
There is a 2015 notification
Yes, it was.
of the government of India,
Oh.
which has been adopted by AEGCL, APDC.
2017.
If we go into deeper, then if I give that direction, then everything will be vacant in your plot of land. They have acquired that right of use way for permanent nature.
But they have not evicted us. They allowed
no.
us to remain there.
No, you are the landowner.
Yes, Lordship.
There is no doubt about it. And they have the duty to
Lordship.
keep it safe.
Lordship.
If something got snapped, you have a right to seek compensation.
Lordship.
Line got snapped on 7/9/2022 as per your application. Forget about 1996, those are barred by limitation. Don't agitate that issue. But
3 times-
7/9/2022 is an admitted fact. And they considered it as per the direction of the coordinate bench, second round.
Lordship.
Fact-finding report, electrical advisor, negative. Land revenue staff, negative. And it is not that, it is a perverse report.
Lordship, then
Sufficiency and adequacy of the fact-finding report cannot be gone into it. You need evidence then in some other case. And these trees were planted.
that is their contention. But Lordship, as per earlier
And
report, there
if this land, madam, then give that notification. That 35 meter both sides, lead evidence before the court. Right, that my tree which were damaged by snapping of trees on 7/9/2022 is outside the right of way.
Right.
For that, you have to lead evidence before the trial court. Right, but for us, it is a notification from us, section 64 or issue kora notification. 2000 Government of India.
2017.
This has been adopted by state government, APDCL in
Yeah, our state
2017,
government
but
adopted
original notification
central
is of
government, yeah.
2015. So you can have a claim. What is the KV?
KV 200 KV.
2020.
2020 KV.
2020.
No, 220 kV.
2020. Then
220 KV.
the line in between and total distance 35 meter. Line goes this way and you have to keep it vacant 35 meter total as per the notification. And this is law. You
1987,
measure and lead evidence there.
if the notification came later on, the
No, it is in 2015.
1987, the
No. I am closing this 1996, 2010. These are all barred by limitation. Making an application will not do.
Lordship may not record 2010, 1996 anything. If they can prove before the learned trial court, then they may hesitate their claim over there.
You, it was the Asila Motor writer with the Sakti Tubes. Heard Miss R. Chaudhary. Learned Senior Counsel, estate by Miss. Learned Counsel for the petitioner. Power.
1, 4 and 6.
Okay, Mr. S. Roy. Learned Junior Government Advocate for the respondent number 1,
4 and 6.
4 and 6. And Mr. S. Kotuki, Learned Standing Counsel, Assam Electricity Giri Corporation Limited. For the respondent number 2 and 3.
5.
2, 3 and 5. Post of para. It is the case of the petitioner that he and his family members who are successors in interest of late Sokat Ali
Yes, Lordship.
shifted their residence to a plot of land covered by periodic pattern number 103, situated at village Jogigupa Bhatipara.
Yes, Lordship, that is Jogigupa and Bhatipara.
Jogigupa Bhatipara. Post Office Police Station, Jogigupa, District Bongaigaon, Assam. In the year?
After 1966.
No, new place.
1996, their earlier place was acquired, so they shifted to this place.
No, new place,
Yes,
place.
new
When?
After 1966. Lordship.
1966, right? In the year 1996. Full stop. And constructed dwelling houses after such shifting, the family constructed dwelling houses and planted different trees in the said plot of land. Post of the petitioner is has been residing in the said plot of land since then. Post of para. It is an admitted position that a transmission line overhead transmission line, that is 2220 kV BTPS alia transmission line was installed between 1985 and 1987. And the said overhead transmission line has gone over the petitioner's parcel of land. The transmission line was installed by the Assam electricity was installed by Assam State Electricity Board, erstwhile Assam State Electricity Board, and the said overhead transmission line is presently subsequently maintained. Now, after trifurcation of the ASCB, the operation and maintenance of the said overhead transmission line has been transferred to the Assam Electricity Grid Corporation Limited, AEGCL. Full stop. Para. At an earlier point of time, the petitioner with his 6 brothers and 2 cousin brothers approached this court by way of a writ petition, WBC number 1981/2011. On the premise that at the time of construction of the transmission tower, no compensation was paid to the petitioner's family. There was an allegation that the said overhead transmission line collapsed twice, once in 1996 and again in 2010. Full stop. The petitioners made a prayer. The petitioners sought for a direction to the respondent authorities to pay compensation to them and also to ensure the protection of their land from the overhead transmission line. Full stop. Para. The court, after consideration of the materials in the pleadings, found to have reached following findings of fact. Page 18. 1, 2, 3. Contrary to the claim made by the petitioners in WPC number 1981/2011, the court had found that the compensation, an amount of rupees 36,630 was assessed and paid towards compensation for acquiring the right of way for installation of the 220 kV overhead transmission line under the provisions of the Electricity Act 1940?
2003.
2003.
Or earlier. That is.
What was repealed by 2003 Act? 1940 perhaps.
I'll give you right now.
Under the Electricity within brackets Supply Act 1948?
My lord.
1948, Lordship.
Since repealed. The court had further observed that the claim of the petitioners for compensation on account of damage of their lands would require factual determination. With such observations, the court declined to entertain the writ petition, and the writ petition was dismissed by an order dated 22/03/2012. Post stop. The court has further observed that notwithstanding the dismissal of the writ petition, if the petitioners would have any grievance over the overhead transmission line, it will be open for them to take recourse to the provisions of Section 68 of the Electricity Act 2003. Full stop. After the dismissal of the writ petition, the respondent number, or he is not a respondent, the respondent 6, office of the respondent number 6, submitted I wrote a letter to the AEZ, respondent AEZCL authorities on 23/02/2021 for ensuring protection of the family as per the provisions of Section 68 of the Electricity Act 2003. Full stop. With the said letter, a joint survey report of Zirat structure submitted by the circle officer, jurisdictional circle officer, in respect of the petitioner and others, was also forwarded, wherein an amount was mentioned to be payable as compensation as per the joint survey and assessment report. Full stop. Seeking a direction to the respondent authorities to implement the letter dated 23/2/2021, the petitioner hearing approached this court again by a writ petition WBC number 6720/2022. Full stop. In the said writ petition, the petitioner had asserted that the overhead transmission line snapped on 2 occasions, causing damage to the residential houses, trees and other valuable properties of the petitioner. No, 1996 and 2010. Referring to the liberty granted by the court in the order dated (22 3 2012) to seek recourse under section 68 of the Electricity Act 2003. The petitioner instituted the writ petition. Full stop. The writ petition WC number 6720/2022 came up for consideration on 12/2/11/2022. Post of the court. Taking note of the provisions of section 65(8) within bracket 5 of the Electricity Act 2023 had observed that the same said provision of law is not a provision to enable any compensation for properties upon the overhead lines being constructed by the transmission utility, nor it is a provision for payment of damage of any property which might be lying below the overhead lines. In the event the overhead lines snapped, resulting in any damage being caused. In view of the provisions of section 68(5) of the Electricity Act, the court did not accept the survey report prepared. Did not accept the survey report prepared and forwarded by the letter dated 23/2/2021, wherein a request was also made to the AEZ sale authorities to pay the compensation that had been assessed in the survey report. Full stop. Observing so, the court had recorded that the prayer made in the said writ petition for a direction to implement the letter dated 23/2/2021 was unacceptable. Full stop. And the subpara. While disposing of the writ petition WPC number so and so by judgment and order dated 2/11/2022, the court had also observed that if the court granted liberty to the petitioner to make an application before the respondent number 2. Respondent number 2. Stating the detail as to when the snipping of overhead line had taken place and what were the legitimate properties of the petitioner that were damaged because of such snipping. Full stop. The court had further observed that upon such application being made, the respondent number 2 would make a thorough inquiry on such allegation, and for that purpose, the petitioner would also make an application before the senior chief electrical inspector of the government of Assam, who in turn would make an inquiry and give its report. First up, if the report of the senior electrical inspector as well as the conclusion of the respondent number 2 was in favor of the petitioner that his property were damaged because of negligence on the part of the AEZCL due to stamping of the overhead transmission line, then the appropriate compensation be assessed and be paid to the petitioner. First up, it is in the above backdrop, the petitioner submitted an application before the respondent number 2 on 11/1/2023, making specific reference to an incident occurred on 7/9/2022, apart from the incident earlier to incident of stamping of 1996 and 2010. Post on receipt of the application, the respondent number 2 as well as the senior chief electrical inspector, respondent number 4, caused an inquiry from their end into the incident of snapping. Full stop. After inquiry by the respondent number 4, a report was submitted before the respondent number 2, wherein it was mentioned as under page 34. Do you number parat bold dot thakin? In the meantime, the respondent number 2 has also received a report on 19/9/2012 of report dated 19/9/2012, also perused the contents of a report dated 19/9/2012 submitted by the Latmulder of the area concerning the petitioner's parcel of land. In the said report, it was reported that the petitioner's family had planted trees on the after the installation of the overhead transmission line in between 1985 to 1987. As per the said report, prepared on the basis of records available, after the incident of snapping of the overhead transmission line in the year 2010, the petitioners planted trees and constructed houses as per their will in the transmission line corridor without taking any permission from the concerned authority or maintaining any safety measures. Based on the findings recorded in the report of the chief electrical inspector, advisor, respondent number 4, and the report dated 19/9/2012 of the Latmundal, the respondent number 2, recorded a finding to the effect that the trees and houses that were present under the overhead transmission line or within the transmission line corridor should not have been present in the transmission line corridor as per the electricity rules. On the basis of said finding, the respondent number 2 has come to a conclusion that no properties of the petitioner were found damaged because of the negligence on the part of the AEZCL authorities. We'll come back at One coconut tree.
Yes. It is in the report reflected that one coconut tree, but the contention of the petitioner is that some more trees are there.
Para. From the order dated 15/6/2024, passed by the respondent number 2, this court finds that the said authority has reached the conclusion on the basis of two reports, submitted separately, two reports, two fact-finding inquiry reports submitted by the Chief Electrical Inspector cum Advisor, Government of Assam, respondent number 4, and the jurisdictional land revenue office staff, post op. The respondent number 2 has recorded a finding on the basis of said two fact-finding inquiry reports that the coconut tree which was damaged due to the snapping of the overhead transmission line on 7/9/2022 was planted after the earlier incident of 2000, snapping incident of 2010, and that too inside the overhead transmission line corridor without taking permission from the AEZCL, who exercise the right of way within the overhead transmission line corridor, the coconut tree, the damaged coconut tree is does not come within the scope and ambit of the provision of section 68(6) of the Electricity Act. First of para, it is relevant. In matters of acquiring right of way for stringing of transmission lines apart from the provisions of the Electricity Act 2003. Okay, না লাগে, না লাগে, না লাগে, না লাগে, না লাগে। Proceed. Para. The Government of India in the Ministry of Power, after analyzing all the issues related to right of way for laying of transmission line in the country, and in order to formulate a uniform methodology for payment of compensation in that connection, paragraph 20. Then this 10/3/2017, right?
Yes.
Paragraph 21. In the circular dated 15/10/2025 of the Ministry of Power, Government of India, and a notification dated 10/3/2017 of the Power within bracket Electricity Department, Government of Assam, for an overhead transmission line of transmission voltage, 220 kV. The width of right of way within bracket in meters is 35 meters. The landowner over the land of which whom an overhead transmission line is installed, overhead transmission line of 220 kV is installed, planting of tree after the transmission utility licensee acquires the right of way is not permitted within a width of 35 meters. Post of as this court in exercise of power of judicial review available under Article 226 of the Constitution of India does not proceed for determination of facts. In the event fact-finding inquiry reports are available and the competent authority bases its conclusion on the basis of the findings recorded in the fact-finding inquiry report, this court does not act as the appellate authority, does not sit in appeal over such findings of facts and conclusions. Post of a conclusion reached by a competent authority can only be interfered within a limited scope when can only be interfered in a limited sphere when the conclusion reached by the competent authority is of perverse nature, because of such a situation is not found to be present in the case in hand. And therefore, this court is of the considered view that no interference is called for in respect of the order dated 15/6/2024 passed by the respondent number 2, which is impugned in this writ petition. Consequently, the writ petition is found to be devoid of merit and is liable to be dismissed. It is accordingly dismissed. The writ petition is
But
accordingly
liberty may
dismissed.
be granted to approach the civil court, Lordship.
That I have indicated 35 with 35 meter.
Lordship.
And if it violates, then you will be punished. So for a coconut tree, we are scratching our head.
Not a coconut tree, Lordship.
Important.
There are some other trees also and houses also. Building is there, Lordship.
Lead evidence that is available to you.
Obliged, Lordship.
Approach the civil court.
Lordship. That liberty, Lordship, otherwise the.
Finding
period
of fact recorded. So you challenge that finding of fact.
Lordship.
Because adequacy or sufficiency, unless it is perverse.
It will, the limitation question will arise, Lordship. That is why, Lordship, if any, that.
Read Soctitius.
Obliged.
Soctitius. Avail section 14. Mr. Taludar, second half we have reserved for few other cases which are part heard.
Some other day.
Some other day. We call this for two types.
I'm sorry. I was in election another.
Just after the vacation, my lord. Just
after. S.K. Taludar, learned counsel for the petitioner, Mr. P.C. Day, learned counsel for the respondent number 7 to 11. And who else are there? Mr. S.S. Roy.
4 and 5.
S.S. Roy for junior government advocate for the respondent number 2, not 2, 3, 6. GMDA, GMCA.
4 and 5.
S. Bora, GMC, GMD, 4, 5. Revenue. Revenue, anybody available? Okay. As sought for. A for side, revenue. As sought for. And agreed to by the learned counsel for the parties, list the case on sides.
He'll give that.
3007.
All the others. Absolutely close. Any admission was any given?
That's item 6.
6.
Item number 6.
Lordship,
Yes, madam.
Here I pray for some time, Lordship, I am awaiting instruction. They have filed amended writ petition, Lordship. So request.
Okay, Ms. R.R. Kakuri, learned counsel for the petitioner is present. Mr. S.S. Roy, learned senior government advocate for the respondent number 5 to 8, has sought for further time to file a counter affidavit to the statements and averments made in the amended writ petition.
Lordship, as a last chance, Lordship, because it's a
Let
long
them-
pending matter, Lordship.
The prayer made by Mr. Roy is accepted, lays the case on silence.
3007.
Yes. 9, 2, 3, 4, 5. Yes, anybody else are waiting, Mr. We'll take up your case, but let us proceed with part heard matters first. It will take time. Who else are waiting? Mr. Bhattacharya? We don't think it will be possible today. That is what I. So no need to keep all of you waiting. I'll take up 2 to 5 and thereafter 27. It will take time because 2 to 5, they are convicts who have spent 20 years in prison already. So we'll take up those cases.
Item 21, your lordship, date may be.
Okay, 16. K. Bhattacharya, petitioner. Respondent? Anybody else?
SS Roy,
B. Goswami.
oh, Mr. R. Kakoti. P. Kakoti, Learned Counsel for the State Respondents are present. As sought for and agreed to by Learned Counsel for the parties, leaves the case on so and so.
4th August, 0408.
Not 16, you already, list is full. He is in better position than
Item 21.
NN Upadhyay. NHAI, Mr. R. Boro, Learned Counsel on behalf of the respondent, NHAI authorities. SS Roy. Okay. Revenue, aforesaid are present as sought for and agreed to release the case on so and so.
0408.
04.
4th August.
JC Gore, 20. AIDC, anybody else?
Your Lordship,
Okay.
for the respondent AI,
Miss
item M. Khan for D.
M.
Deca.
Khan. On behalf of
D. Deca.
D. Deca, Standing Council, AIDC. Are present. Same as so and so. Release the case on so and so.
0608. 6th August.
Much obliged.
Oh, no, other matters. I'll be taking up 6 other matters. Part heard.
My matter is.
Which
very
will take
unlucky,
some
actually.
time.
Wherever he goes, Padhar also remains, but he has to release.
What to
because
do?
He is out of station.
What to do?
Any.
Which item, madam?
First week of August.
Which item?
Item 19.
19. Okay, ma'am, Miss N. Soikia. SS Roy. Your
Yes. 5. 5th of August. After vacation, now no more July.
Saidu.
0608. 6th August.
06. Thursday. Hearing.
August.
August.
Items 2 to 5.
Sure.
Numbers 2 to 5.
May please, Your Lordship. The arguing counsel is on court number 3, then like Your Lordship.
Anyway, it is for me to do everything. How do I do it? দুটা পেৰা বাদ দিম। এই when it will be possible for Mr. Atreo to come?
About 10 minutes.
দুটা পেৰা submission খিনি বাদ দিব পিছত পাৰে। CRPC, PNSS. Para 7, 8 by 9. Proposal. Proposal কিছুমান আছে ক'ৰবাত আছিল না? Oh, Mr. Roy, you submitted the proposal along with the affidavit?
Yes.
That review board?
Yes. Affidavit be subsequently filed.
So take note of the facts, right?
Lordship.
I'll dictate to the extent possible today, Lordship. The provision for remission of sentence was contained in section 432, Code of Criminal Procedure 1973. Which has since been replaced. The codes here basically by the Bharatiya Nagarik Suraksha Samhita 2023, BNSS. In the BNSS, the provision for remission of the sentence. Yes, Mr. Atre will dictate the order to the extent possible today. Is contained in section 473. Full stop. For the provisions of section 432 CRPC are similarly, the provisions of section 473 BNSS are similarly worded as section 432 CRPC. Full stop. For the purpose of the cases in hand, subsection 1 and subsection 2 of section 432 are of relevance, and they are quoted hereunder for ready reference. Oh, wow, sorry. Subsection 1, subsection 2, and subsection 7. The power of remission available to the appropriate government under section 432 CRPC stroke 473 BNSS is for remission of the whole or part of the punishment to which an accused has been sentenced, and such remission can be without conditions or upon any conditions. Full stop. The power under section 432 CRPC stroke 473 CRPC is subject to the provisions contained in Section 433 A CRPC stroke 475 B and SS. Full stop. Section 433 A CRPC stroke 475 B and SS is with a non-obstante clause related to section 432 CRPC stroke 473 BNS. Full stop. Section 433A stroke section 475 BNSS has
This project, it's 476 in my copy of the BNSS.
oh, I'm sorry. 475. 475 BNSS. Restriction on powers of remission
Yes, yes. My apology. 470.
has prescribed that notwithstanding anything contained in section 432 CRPC stroke 473 BNSS, comma, where a sentence of imprisonment for life is imposed on conviction of a person for an offense for which death is one of the punishments provided by laws, comma, or where a sentence of death imposed on a person has been commuted under section 433 CRPC stroke section 474 BNSS into one of imprisonment for life, comma, such person shall not be released from prison unless he had served at least 14 years of imprisonment. Full stop. Meaning thereby, the appropriate government cannot grant remission unless the convict has served at least 14 years of actual imprisonment in the category of cases mentioned therein. Full stop. It has been held in, you relied upon Sangeet, right? It has been held in Sangeet. Versus State of Haryana. Two 2013 2 SCC 452, comma, to the effect that The process of granting remission under section 432 CRPC and for that matter, section 473 BNSS can be set into motion in a case only after an application for remission is submitted by a convict or by a person on his behalf. First of all, such an application being made, the appropriate government is required to approach the presiding judge of the court before or by which the conviction was made or confirmed to opine within bracket with reasons whether the application should be granted or refused, full stop. Thereafter, the appropriate government may take a decision on the remission application and pass orders granting remission subject to some conditions, or refusing remission. Post. The Constitution bench decisions in Gopal Binayak Godse versus State of Maharashtra, AIR 1961 SC 600 and Maruram versus Union of India 1981 1 SSC 107 had taken note of the fact that life imprisonment means that the prisoner would remain in prison for the rest of his life. And credit for remission given or awarded has a meaning only if the imprisonment is for a definite period. Since life imprisonment is for an indefinite period, remissions earned or awarded are really theoretical. In matters of life imprisonment, remissions earned or awarded would become relevant only if there is a fictional quantification of the period of imprisonment. Full stop. It has been held that remissions earned or awarded cannot be the basis for determination of the fictional period of imprisonment. Following the said two decision, the Honorable Supreme Court in Ashok Kumar versus Union of India 1991 3 SSC 498 has observed that where a person has been sentenced to imprisonment for life, the remissions earned by him during his internment in prison under the relevant remission rules have a limited scope and must be confined to the scope and ambit of the said rules and do not acquire significance until the sentence is remitted under section 432, in which case the remission would be subject to limitation of section 433A of the code, or constitutional power has been exercised under Article 72 stroke 161 of the Constitution. Thus, for a life convict, to reduce the period of incarceration, a specific order under section 432 CRPC stroke 473 BNSS will have to be passed by the appropriate government. However, the period cannot be less than 14 years as per section 433A of the 433A CRPC stroke 475 BNSS. It has been held in Sangit Supra that section 432 CRPC has application only in two situations, paragraph 77 was 1, where a convict is to be given additional remission or remission for a period over and above the period that he is entitled to or he is awarded under a statutory rule framed by the appropriate government or under the jail manual. And 2, where a convict is sentenced to life imprisonment, which is for an indefinite period, subject to procedural and substantive checks. As it has been observed therein that before actually exercising the power of remission under section 432 CRPC, the appropriate government must obtain the opinion within bracket with regions of the presiding judge of the convicting or confirming court, and remission can be given only on a case-to-case basis and not in a wholesale manner. Here you have given wholesale. Where is the office memorandum? page 39. This is based on Sangeet
Yes, Raj. There's a reference, I think, to.
490.
criminal
Right.
information.
Yes.
Yes.
After the decision in Sangeet, decision of the Honorable Supreme Court in Sangeet, comma, the state government in the Home Department in order to follow a uniform policy for granting remission of sentences to life convicts and all other convicts, page 39 or something, huh? Sentenced to imprisonment for more than 14 years in aggregate and in has issued an office memorandum on 6/10/2015 on the subject, quote, remission of sentences of life convicts, unquote. Para, in the said policy framed by the state government and notified by the office memorandum dated 6/10/2015, comma, it has been emphasized that for granting remission in respect of life convicts, the germane factors for consideration should be the age of the convicts, comma, the physical strength of the individual, so as to assess the danger that an individual is likely to pose in the society in the event of his release. Full stop. The factors whether the prisoner who has become frail or suffering from terminal diseases and would not privacy pose any threat to the society would also be a relevant for consideration. Full stop. In clause 6 of the office memorandum, comma, it has been laid down that to the effect that the state government shall examine a proposal received from the Inspector General of Prisons along with the opinion of the presiding officer of the convicting or confirming court, comma, as the case may be, by giving due regard special consideration to the following class of prisoners while taking decision. Page 40. A and B. From the office memorandum, anything else? In clause 8 of the office memorandum, comma, it has been reiterated that remission proposal shall be decided case to case on merit, and no decision in this regard shall be taken on a wholesale manner.
Chip in 7 also there is a condition. Adverse effect on the society.
Okay, that will come in Ram Sundar.
Yes, Ramchandra.
In clause 9, it is mentioned that proposal of remission rejected by the government, state government, comma, after due consideration, comma, should not be resubmitted before expiry of 2 years from the date of rejection, comma, except where the person is more than 80 years in age or terminally ill. Full stop. Para. So far as these 4 petitioners are concerned, comma, all of them have spent more than 20 years in incarceration as on date. Full stop. The petitioner, who is the last one, 75?
Holiram Bordelin.
The petitioner in WPC number,
524.
in the writ petition, comma, WPC number 524.
524 to correct. 524, Lordship. 524.
524, 2026 is, comma, as on date, more than 75 years of age. Full stop. For the purpose of, where is that review board provision?
Lordship, that is at
Which act?
section 22 of the Assam Prisons Act, 2013.
Prisons Act.
Page number 2 get up correct. Jail management code, section 22. Page number 2. 103 of the book.
কিতাপখন আছে না? কিতাপখন ক'ত আছে? এইখন। এইখন। The Assam Legislative Assembly had enacted the Assam Prisons Act 2013 for consolidation of the laws relating to prisons and persons detained therein in the state of Assam. In Section 2. As per section 2 within bracket 24, comma, quote unquote, imprisonment for life means imprisonment for the entire life of the person under sentence of imprisonment for life, comma, unless such sentence is remitted earlier by the appropriate government. Full stop. Remission is defined in section 2 within bracket 27 of the Assam Prisons Act. Full stop, quote unquote. Remission means a concession granted under the provisions of section 65 to a convicted inmate, comma, as a consequence of which the sentence of imprisonment, comma, except where the sentence is one of imprisonment for life, comma, of the inmate is shortened. Also. Section 22 of the 2013 Act has provided for constitution of a review board. So subsection 22 has prescribed that the state government shall constitute a review board in the manner as may be prescribed, in the manner as may be prescribed, to review the cases of inmates under sentence of imprisonment and recommend their premature release under any law, comma, including parole and day release. Under any law, as inter alia prescribed. Full stop. The provision for remission is contained in section 65 of the 2013 Act. Any rules have been framed?
Lordship, rules are within under the old jail manual, no new rules.
Okay,
Because, Lordship, there is a savings provision.
okay. Subsection 3 of section 65 has laid down to the effect that an inmate sentenced to imprisonment for life to be released is not to be released without specific orders from the appropriate government remitting his sentence of imprisonment for life. Others are not material. Okay, which provision? In the jail.
Lordship, may please also have the savings clause. Section 92 of the Act.
Section 92 of the Act.
92 of the Act. Page 131 of the book. Section
By virtue of subsection 2 of section 92 of the 2013 Act, what is the name of the rules?
the rules for superintendence and management of jails in Assam.
The rules
272 is the name.
The rules for superintendence and management of jails in the state of Assam, framed under Section 3 within bracket 1 of the Prisons Act 1894 have been saved. Chapter X1X of the said rules contained provisions for the remission system.
Chief, this has been framed under section 59(5) of the Prisons Act.
Hmm?
This particular chapter.
This chapter
Yes,
of
of the Prisons Act 1894.
the entire rule has been framed.
Yes, Lordship, but the provision is different. Every chapter has been framed under a separate provision.
Okay, which was framed under section 59(5) of the Prisons Act 1894 to regulate the shortening of sentence by the grant of remission. Yes, which part is of relevance?
Lordship, Rule 571, which is also quoted in the OM. That is the process for release of bail.
571.
Page 460. Sub-rule 4 is the process.
Sub-rule 4 of Rule 571 of the rules নাম দিব লাগিব ন of the Assam jail rules করে দিও provided for the procedure about submission of a proposal for remission and it in the following manner, page 461. In the light of the it is not in dispute that proposals in respect of each of the petitioners was submitted by the superintendent of the concerned jail as per the procedure laid down in the Assam jail rules and came to be placed before the review board for consideration. Full stop. What is 327A?
Lordship, that is with respect to remissions when an individual has been sentenced to life without
Page 391.
327A after commutation of death sentence. In those cases, remission would not be allowed.
Insert it.
And thereafter, Lordship had seen on the last occasion, there is a note by which it is said that 327A was since deleted.
Where was that?
That is Rule 571 at page 461.
So it is deleted. It stands deleted.
It stands deleted according to this.
So not required to mention.
Yes, yes.
The manner in which a proposal for remission submitted on behalf of a life convict has been considered by the Honorable Supreme Court in a number of cases. Justice Sadhu. This. That procedure requires consideration of a police report also?
Yes, Lordship. Of a police report and a report from the district magistrate.
Assam prison. What is that rule? Rule 5?
71.
There is nothing in sub rule 4 regarding police report.
That is in the OM, Lordship. I'll just verify.
OM.
Yes, Lordship, at page 40. Of the writ, Lordship.
Which paragraph?
Para 1, Lordship. Fourth line from the top.
It has been laid down in the office memorandum dated 6/10/2015 that page 40. Clause 1. All applications made by a convict or on his behalf for remission of sentence should be submitted to the superintendent of the jail. The latter in turn will take steps to forward the same to the presiding judge of the convicting or confirming court with the history ticket, copy of the judgments, descriptive rule, report from the district magistrate and the superintendent of police of the district of the convict's conduct, report of the medical board in case of old, thus infirm, and terminally ill convicts for his opinion, within bracket with region, bracket close, about granting of remission. First. In Laxman Naskar versus Union of India and others, 2000, 2 SCC 595, and it has been reiterated in Ram Sundar versus State of Chhattisgarh and another, 2022, 12 SCC 52, that a police report call for consideration of a proposal for remission should deal with the following factors. Right, one. Yare 1, 2, 3, 4 আছে Ram Noskar paragraph 6 hote আছে. Whether the offense is an individual act of crime without affecting the society at large, whether there is any chance of future recurrence of committing crime, whether the convict has lost his potentiality in committing crime. 4, whether there is any fruitful purpose of confining this convict anymore. 5, social economic condition of the convict's family. What was relevant from Jagdish?
Para 46, Lordship. Same factors as Lakshman Naskar, been summarized.
In State of Haryana and Jagdish, 2010, 4 SCC 216. It is observed that at the time of considering the case of premature release of a life convict, the authorities may require to consider his case mainly taking into consideration Para 46. In Ramsundar Supra, comma, the case for remission of the petitioner who was a life convict, comma, was not given the benefit of the provisions of section 433A CRPC by the state government initially because the presiding judge opined against releasing the petitioner on remission. Full stop. When the jail department sought the opinion of the law department, the law department stated that since the presiding judge of the sentencing court had not given a positive opinion with regard to the release of the petitioner could not be released. Full stop. In such factual scenario, the Honorable Court has examined the issue what value is to be given to the opinion of the presiding judge. The Honorable Court referred to the Constitution Bench judgment in Sriharan. Union of India versus Free Sriharan 2016 7 SSC 1, wherein it was held that, wherein it was observed that the appropriate government would get the needs to get the valuable opinion of the judicial forum, which would throw light on the issue relating to grant of remission. First of having regard to the nature of opinion to be rendered by the presiding officer of the court concerned, which will throw much light on the nature of crime committed, the record of the convict himself, his background, and other relevant factors, would enable the appropriate government to take the right decision as to whether or not remission of sentence should be granted. And the ultimate order of remission should be guided by the opinion to be rendered by the principal judge of the court concerned. The court has proceeded to observe that the opinion of the presiding judge following Sriharan has proceeded to observe that the opinion of the presiding judge shines a light on the nature of the crime that has been committed, the record of the convict, a record of the convict, their background and other relevant factors. It is crucial that the opinion of the presiding judge is crucial in the sense that the same would enable the government to take the quote unquote right decision as to whether or not the sentence should be remitted. So at the same time, it has been observed that the opinion of the presiding judge is not the only relevant factor, which would have a determinative effect on the application for remission. Full stop. The purpose of the procedural safeguard under section 432(2) CRPC would stand defeated if the opinion of the presiding judge becomes line to bullish. It cannot be said that the opinion of the presiding judge is only a relevant factor, which does not have any determinative effect on the application for remission. The purpose of the procedural safeguard under section 432(2) CRPC would stand defeated if the opinion of the presiding judge becomes just another factor that may be taken into consideration by the government while deciding the application for remission. It is possible then that the procedure under section 432(2) would become a mere formality. However, the same would not go to the extent that the appropriate government should mechanically follow the opinion of the presiding judge. Full stop. If the opinion of the presiding judge does not comply with the requirements of section 432(2), or if the judge does not consider the relevant factors for grant of remission that have been laid down in Lakshman Naskar Supra, the government may request the presiding judge to consider the matter afresh. Okay, we'll stop at that. Tuesday.
Obliged.
Lordship, Tuesday, I may not be there.
I will keep a proxy.
Lordship.
Lordship, so desires I may submit a written argument with Lordship.
No, you get give your submissions.
Yes.
I am dealing with it. So give your submissions
Sure.
within 1 page.
Obliged.
Pardon, Mr. So-and-so, so-and-so, as the arguments are not concluded, raise the cases again on Tuesday as part of the items.
Obliged.
Try to have a Monday, 10:30. Draft whatever I have.
Yes, yes.
Had it been one case, it would have been easier.
Supplementary list, item 27.
Yes.
My lords.
Is it possible to conclude by 4:30?
Yes, my lords. I mean, we are on a very limited point, my lords.
So. Okay. You are a government of Assam undertaking.
Yes, my lords. But my lords, there's a little, I mean, the last, when we broke, my lords, your lordship's directions was to try and distinguish the case law which he has relied upon, saying that if there's a predetermined quantum in a show cause notice, how will that be dealt with? Now, the case before your lordships, what he's relied upon, deals with the question of cess.
Which one?
My lords, it's
The
Siemens Limited, my lords.
No, the principle.
The principle, my lords, I mean, that the ratio which has basically been propounded by that case law, my lords, will not apply in this case. Here, the situation.
Then we will hear you out on some other date.
Yes, my lords. That's fine.
You are enjoying interim order.
We are enjoying the interim order.
We will consider not the IA full.
Then instead of the IA, your lordship, the matter.
No point.
My lords,
The same effort will go.
The only.
You could have said, then I would have disposed of the other matters.
My lords,
Anyway.
The only difficulty here is, my lords, they are on an ad interim ex parte stay, my lords. I have not been heard on the matter. That stay also was conditional, my lords, and they are now in breach of those conditions.
Now we are thinking of that discretion is ours whether to consider the IA or the anti-writ petition.
I'm just putting it.
And this court is of the view that anti-writ petition should be decided.
My lords.
Right.
Indeed, your lordship.
No point giving 75% effort in IA
Indeed, your lordship.
and thereafter keeping the rest 25% for the other day.
Yes, my lords.
Indeed, your lordship. Your Lordship,
It is not the only one, Siemens, that came to my mind on that day.
Your
There are other decisions.
there is one more.
Here, my lords, the entire dispute is contractual in nature.
No, but you are a instrumentality of the state.
I
And
concede
your
that.
actions should be fair and there should be administrative fair play in action.
I
That
consider that.
content of the notice,
My lords.
we'll examine on that day. We have just
My lords.
cursorily examined.
My lords.
But content of the notice that if you don't do this, this.
No,
The ratio is that.
Yes,
But the
sir.
law says
Yes, sir.
there should not be anything that why action should not be taken against. Because they have, first you have 2 meter readings.
My lords.
2 meter readings you have given. And that
No,
view also is expressed. Prima facie, that was my tentative view, just having a look at the notice.
my lords, if my lordships is indulging, then I'll just show one paragraph, my lords. That dilemma will be completely crystallized, my
So,
lords.
well, here you are. Then
Yes,
I am
Lord, yes, Lord.
exhausted by this time.
It comes
I
from
thought
the
that,
contract itself.
On the basis of whatever we understood
Your
that
Lordship,
day.
there's one more case law that I would like to put forward. Your Lordship may make it a part of the report. Your Lordship, this is
But
also-
both of you, before vacation, I don't think. Next days will be motion days. We can keep it, but I don't think it is possible.
Your Lordship.
Tuesday
then
is blocked
subsequent
again.
to the vacation if it is. Because Your Lordship,
I will-
even I will not be available after the 25th.
Before that, then 25th July.
June.
Okay.
So it has to be after the
Punya
vacation.
Commerce is out. Punya Commerce.
14th of
14 years of okay.
14 July.
14 July. Okay, then 14 July.
14 July. Very well, my lords.
Because I don't know, it will be answered in the next week.
Indeed, Your Lordship. It'll be a
PM
miss-
Borua petitioner.
My lords, there's a difficulty on the 14th. Any day after that.
It should be a hearing. That's
A
fine.
hearing day. Anything after.
Thursday, any Thursday.
Any Thursday. But not between 16th of July.
Asiva. Okay. Hey Khanna. SS Roy likhi dibo. Jyotat se. This the case again on 16th, 16/7. Interim order, if any, shall continue.
Indeed, Your Lordship.
We'll do that on the.
Obliged.
Yes, I would have dictated the other cases. Mention hয়েছে mention হওয়া নাই সব কোনটো
Item 24.
Oh, okay, let it left over. Let it left over. I already indicated that I will not take up the hearing matters because of some other issues. So council may have gone.
Yes,
I should not record their absence now.
Obliged.
I should not record their absence now.
Obliged.